Thank you. Thank you. Yeah. Court calls, cause number 1, 2, 3, 4, 5, 6, 7 to trial Sylvia Scott individually as representative of the estate of Ryan Scott deceased versus SBB LLC, doing business as Spyglass Vista Apartments. Can I have council's appearance and trial announcements, please?
Good afternoon, Your Honor. My name is Cristen Flanagan, and I'm alongside my co-counsel. We have the honor and privilege of representing the defendants, Spyglass Vista, in today's matter. We do have a couple of housekeeping matters and motions we need to review.
Okay, can I get your name again, please?
Enrique Contreras, ENRIQUE, Contreras, CONTRERAS.
And Plano, can I get your appearance?
Good afternoon, Your Honor. My name is Raygen Lee, and I, along with my co-counsel, Katherine Sartain, represent plaintiff Sylvia Scott individually and on behalf of Mr. Ryan Scott for his estate.
And I understand that we have some housekeeping matters that we need to take care of.
Yes, Your Honor.
All right, let's start with plaintiffs.
Your Honor, first, we are operating with the understanding that is being this trial will be guided by the Texas Rules of Evidence and Code of Civil Procedure. May we proceed with that understanding?
Yes.
May we proceed also with the understanding that the witnesses have previously been sworn in?
Yes.
Your Honor, we defense counsel and we have agreed to all of the exhibits being previously authenticated, and we have agreed to majority of exhibits being pre-admitted. We do have we have a list for you. We have a few that are not agreed to as far as admissibility. But may we proceed with our previous agreements with each other?
Yes, do you want to put those agreements on the record?
Yes.
Your Honor, during pre-trial conference, the parties agreed to pre-admit the wedding photo. That's page 25. The screenshot, page 26. A map of Cairo, page 40. And then the other two exhibits we do have machine used.
Okay. We've also agreed to pre-admit both expert reports.
Any other exhibits that y'all have agreed to pre-admit?
No, Your Honor, it's just those three.
And the expert
Or
reports?
the expert reports.
All right. Are we going to designate these by page numbers or?
Lines. Line numbers. Line pages, yes, Your Honor.
So 25, 26, and 40 are admitted. The expert reports are admitted as well. Let's take out the two, yes.
Sorry, Your Honor, one additional thing, we also have agreed to, we will be, both parties will read into the record deposition testimony from Mrs. Scott. We would like to admit that as an exhibit as well.
The deposition?
Well, we would like to make sure that the deposition testimony that will be read in is, we're in agreement on that.
Okay, perfect. All right, let's take up the two exhibits that are not pre-admitted.
Your Honor, before we do that, may I go over my housekeeping matters?
Sure.
Thank you, Your Honor. May we move free about the Welder opening and closing arguments,
Yes.
as well as examinations? Okay. Thank you, Your Honor. The parties did share their blood exhibits and their objections to those being used.
Okay.
And that concludes our housekeeping matters.
All right, now are we ready to take up the exhibit? Yes. Let's start with the first one.
Your Honor, plaintiff sole motion in limine today is regarding the employee file of Mr. Ryan Scott. This file is a record kept by the manager of Spyglass Vista Apartments. It's Casey Hayden, who will be testifying here today. This record, first of all, this record constitutes hearsay, including hearsay within hearsay. the entirety of this record includes statements made out of court for the truth of the matter asserted, which is, not allowed by the rules of evidence. And in addition to that, this is an incomplete record, which prevents it from satisfying the business records exception to the hearsay rule. There's deposition testimony that while this file was kept for a portion of Mr. Scott's employment due to a pipe burst on the premises, the files keeping track of the beginning of his employment were not salvaged from this pipe burst, and the employee file that we have here today is an incomplete version of his employee file, and because of this incompleteness of this record, this also constitutes an improper use of character evidence against Mr. Scott, and so we ask that it be any reference to the employee file. Anything included in it be excluded based on hearsay and improper character evidence, and also a 403B objection as this incompleteness and hearsay renders it highly prejudicial, no further value.
Response?
Yes, Your Honor, in regards to the hearsay, by way of background, this case is about Mr. Scott, who is no longer with us. He was killed on a premises. And so we do intend to introduce an employee file of Mr. Scott's behavior. It comes from tenants at the apartment complex that have made several complaints about Mr. Scott's behavior and interactions with the tenants. In regards to opposing counsel's hearsay objection, we do find that this qualifies as a business records exception. We have Ms. Casey Hayden here to testify today, which she is the property manager, and her statements have been authenticated in her deposition. Thus, we do find that it would qualify as a business records exception.
Anything further?
Simply that the reason that opposing counsel has mentioned does not address the incompleteness issue that involves a business record exception.
Your Honor, there is no information in today's evidence that states that this file is incomplete. Ms. Hayden will have an opportunity to be cross-examined and can be asked questions about the incompleteness. But the questions or the evidence that we intend to bring forth about from the employee file are actually completed.
Anything further?
Your Honor, I believe the suggestion that the employee file is completed as it's presented today does not address the fact that it is not complete as a whole, which is the purpose of my objection.
I'm going to overrule your objection. What else do we need to take up before we begin?
Your Honor, if opposing counsel is done with her motions, we do have some motion numbers to discuss before you.
Anything further?
No further motions, Your Honor.
Okay, let's take up the defense motion.
Your Honor, defense moves to exclude the term Prime Row and Guns Point Mall. There's evidence that the apartment complex and other complexes that sit in the area do involve a high concentration of crime. And while we don't dispute that, we do find that it is very prejudicial to label these apartment complexes Prime Row. There's no street named Prime Row. There's no neighborhood called Prime Row. It's just a colloquial term that is just randomly being used. It's not a formal term, and we move to exclude Prime Row and Guns Point Mall under 403.
Your Honor, the plaintiffs, we are not opposed to the exclusion of Guns Point Mall. We have no intention of discussing that issue, but that subject today. However, Prime Row nickname goes to the element that we are one of the elements we are here to prove today, which is dangerous condition for our premise liability negligence case. And the fact that there is this, as the opposing counsel has described it, a colloquial term used by large groups of people in itself, it implies the existence of this reputation in the community. And We believe that this is highly probative, as 403 intends the evidence to be to the development of our case in chief from the plaintiff's side today.
Your Honor, if I may respond quickly. We have no problem with plaintiffs describing the area of the concentration of crime, but to call it crime row when there is no formal name or no, it's not formal. It's very prejudicial. We have no problem with them describing it, but to just randomly throw a label on it, we do not find that should be.
At this point, I'm not going to exclude the use of crime row. Actually, let me rephrase that. I'm going to grant the motion on limiting on crime row. So before you, anyone elicits testimony regarding crime row, you'll need to approach the bench now.
Yes, Your Honor. And we do have one more motion on before review. Defense needs to exclude any reference that Mr. Morris says the shooter in this case was a drug dealer. There's been no conviction. Mr. Gus is not arrested for drug dealer. We have no problems with plaintiffs. Well, the evidence will show that there might have been a suspicion that Mr. Gus was doing some illegal activity. However, to label him as a drug dealer when there's been no formal conviction, you find that this label is prejudicial under 403.
Response?
Your Honor, the suspicions of, just want to clarify that the suspicions of drug dealing and being labeled as a convicted drug dealer are two very different things, and we understand that, and we have no intention of implying facts that are not evidence.
Okay, so it sounds like you're in agreement with your motion.
Well, Your Honor, if I may just briefly add, so the defense would not like for it to be, or for the term to be suspected drug dealer. We would rather language that's suspected of dealing drugs.
Okay, I may respond, Your Honor. Again, as part of our burden today is to show the presence of a dangerous condition, and the suspicions of drug dealing go directly to that element, and if we can't, plaintiffs are unable to talk about this core element of the claims that we have brought, then that would be a incomplete presentation of our case, and would be highly prejudicial. It's not permitted to be discussed.
The motion on limiting is overruled. Is there anything else that we need to take out before we begin?
Your Honor, that's all for defense. We stand ready for trial.
Anything else to say?
No, Your Honor.
Okay. Are we ready to proceed with opening statement?
Yes, Your Honor.
You can proceed.
Your Honor, may I go to the podium? May it please the court, counsel, ladies and gentlemen of the jury. My name is Raygen Lee, and I, along with my co-counsel, Katherine Sartain, represent the plaintiffs in this case. July 19th, 2023. That is the day Mr. Ryan Scott lost his life. And that is the day that Mrs. Scott lost her forever partner, her husband. July 19th, 2023. At Spyglass Vistas Apartments. I ask you to stay with me throughout this process, as we are going to have to talk about this tragic day, and we are going to have to face the details of what led Mr. Ryan Scott to lose his life. At the end of this trial, each of you will have an opportunity to help Mrs. Scott build a new life or some kind of peace after this. As I mentioned earlier, my name is Raygen Lee, and I, along with my co-counsel, Katherine Sartain, represent the interests of a man who was put in an impossible situation. We expect that after today, you will see that that is all thanks to an apartment complex turning a blind eye to crime. Now you're probably thinking, what was this impossible situation? Well, we anticipate that as you listen to evidence or listen to testimony and see the evidence throughout this trial, that you will see that Mr. Ryan Scott was attending his own business at Spyglass Vista's apartments. When all of a sudden he sees two people in a fight, he sees a man throw a woman to the ground. What does he do? He protects, he reacts, he tries to protect her. He sees a woman thrown to the ground by this man. He goes up there. He tries to intervene. And then, just like that, the impossible situation that Mr. Ryan Scott was put in cost him his life. And that situation caused him to take his last breaths that day, July 19th, 2023. Now, you will see throughout this trial that all of this tragedy occurred simply because of a blind eye to crime. Now, we expect how you will see that Mr. Scott was invited to the premises that day. And we expect that the premises that he was invited to was in fact Spyglass Vista's apartments, for which defendants at this table maintain possession or control. We also anticipate the evidence showing that defendants' premises, specifically the parking lot near the front of the apartment complex, posed an unreasonable risk of crime because it encouraged criminal behavior to occur. And more specifically, what was occurring throughout the parking lot and throughout the entire apartment complex, we anticipate the evidence will show you is suspicion of drug activity. And we expect that this blind eye to crime occurring throughout the apartment complex led to the inevitable. Now, we expect that you will see through testimony and criminal reports that Spyglass Vista Apartments knew, or at least should have known, about this criminal activity, and that this criminal activity posed a danger to anyone that stepped on its premises, including Mr. Ryan Scott. Now, before I go, I want to give you a quick rundown of the people that we expect that you will hear from throughout this trial. First, you will hear from Officer Andy Rubenstein. He is a seasoned police officer who spends most of his days working to prevent crime, working to keep people like you and me, Mr. Ryan Scott, safe. To do that, he works with community leaders. We expect that you will hear that he often patrols and conducts criminal surveillance to ensure that crime doesn't continue to breed. We anticipate the evidence will show you that this surveillance and his patrol is focused in a specific area. Now, I want you to keep your ears peeled and think through what is known about this area, and think through who and why someone is turning a blind eye to crime. Now, you will also hear from an expert witness that we will provide. Now, this expert will go through the details of what an apartment complex needs to do to ensure that people on their premises are safe, to ensure that people like Mr. Ryan Scott are safe. I want you to listen through this expert's testimony and ask yourself why they didn't do this. Ask yourself if the apartment complex did anything to try to help Mr. Ryan Scott. Did they do anything to try to prevent the crime that was breeding upon their premises? Now, ladies and gentlemen of the jury, for you to do your job, you need to have the clearest understanding of the full truth. And so defendants will also put on some people. And we expect the defendants will hire their own expert witness. When you are listening to testimony of that expert, I want you to once again ask yourself, where did these numbers come from? What kind of crimes are we talking about? Who and why is turning a blind eye to crime? And finally, we expect that you will hear from the apartment complex's manager herself. And we anticipate that the evidence will show you that the apartment complex did know that something was going on. And we anticipate the evidence will show that they knew all the way back in 2019. And yet, once again, what did they do to protect Mr. Ryan Scott? What will they do to protect the next person? Now, it is our burden to prove to you throughout this case that Spyglass Vista's apartments negligently caused Mr. Ryan Scott's death. And in this case, how we plan to prove that to you, and under the eyes of the law, how we must prove it to you, is by showing that there was an unreasonably dangerous condition upon Spyglass Vista Apartments premises for which they knew, or at least should have known about, and it cost Mr. Ryan Scott his life. Now, I said we have to carry a burden. We're happy to do that because it's an easy burden to carry, especially after all the evidence that you'll hear today. I want to explain what this burden is. It's called a preponderance of the evidence. And really all that means is what is more likely than not. Who do you believe? One side or the other? As you listen to testimony and as you listen to experts and the people who are conducting surveillance throughout an area, where does it point you? What side do you lean on? That is a decision that only you can make. Ladies and gentlemen of the jury, throughout this trial, please listen diligently and continue to ask yourself the questions that I've posed for you already. And understand that only you have the opportunity to provide Mrs. Scott some kind of path towards peace. Thank you.
Okay, opening statement.
Yes, Your Honor. Thank you, Mr. Good afternoon, ladies and gentlemen of the jury. My name is Enrique Contreras, and along with my co-counsel, Ms. Cristen Flanagan, we represent the defendant in this case, Spyglass Vista Apartments. This case is about where responsibility begins and where responsibility ends. Responsibility begins with the man who pulled the trigger, the man who shot Ryan Scott, Morris Gus. That is where responsibility begins. Allow me. A firm, clear line has been drawn by the law. A line between responsibility and tragedy. A line between what someone can control and what they cannot. On July 19, 2023, Ryan Scott lost his life in a senseless, violent act. Nothing we say today is meant to diminish that loss. It was tragic, it was sudden, and it was caused by one man only, Morris Gus. The man who pulled the trigger, the man who fled the scene and remains at large till this day. That is where responsibility begins, and that is where responsibility ends. Now, the plaintiff wants you to cross that line. They want to put the actions of Morris Gus and place them on the shoulders of Spyglass Vista. But the credible evidence will show you that Spyglass Vista did not cause this crime. The credible evidence will show you that Spyglass Vista could not predict this crime. And finally, the credible evidence will show you that Spyglass Vista could not prevent this crime. Now, let's talk about that day. That day, Ryan Scott was terminated by Spyglass Vista. And Spyglass Vista told Ryan Scott not to return to the premises that afternoon. Yet, he did so anyway, for his own reasons, on his own. And when he arrived, he encountered a domestic dispute between two individuals, Morris Gus and Alicia Gomez. A personal dispute, a volatile situation between two people already in conflict. And Ryan Scott made a choice. He chose to intervene. He chose to escalate the situation with confrontational language. And in response, Morris Gus unexpectedly and unlawfully pulled his gun and shot him. That decision of pulling the trigger was not made by Spyglass Vista. No. That decision was made solely by Morris Gus. Now, the plaintiff is going to tell you that this was foreseeable, that Spyglass Vista should have seen this coming. But no, the credible evidence will show you something very different. It will show you that Spyglass Vista took steps to improve security. They installed security cameras, they maintained controlled access gates, and they hired multiple security guards, Ryan Scott included. In fact, crime in Spyglass Vista went down when these measures were put into place. Now, that's not negligence, no. That is called responsibility. You will hear about Morris Gus, the shooter, the man who killed Ryan Scott, a man who passed his background check, a man whose criminal activity was hidden. Not even law enforcement, with all of their resources, could have predicted him acting in this way. Now, the law doesn't require perfection from property owners, no, but it does require reasonableness. And the credible evidence will show you that Spyglass Vista acted as a reasonable apartment complex would under the same circumstances. At the end of this case, the question before you is not whether this was a tragic event. We all can agree this was tragic. No question about it. But the question before you would be, who is legally responsible? Is it Spyglass Vista who took steps to provide safety, to reduce crime, who had no way of predicting this violent act would happen? Or is it the man? The man who pulled the trigger, Morris Gus. The law has drawn the line firmly and clearly, and plaintiff wants you to cross it. Which is why we ask you to allow Ms. Flanagan and myself to provide you with the credible evidence. Because at the end of this case, you will see the credible evidence will show you that Spyglass Vista did not cause this crime. That Spyglass Vista could not predict this crime. And finally, that Spyglass Vista could not prevent this crime. Thank you.
Plaintiff, please call your first witness.
Your Honor, let's call Mr. Raygen to the stand.
Your Honor, may I correct myself?
Yes.
Your Honor, before we get started with the live witnesses, we'd like to call by deposition testimony Ms. Sylvia Scott. Stand constructively, and I will have one of my witnesses stand in and brief the testimony. Okay. Your Honor, my apologies. This might have needed to be cleared up in housekeeping, but we do have cross designation. Would you like that read full, or would you like for us to go ahead and do our examination?
I typically let the attorneys try to repeat, so at whatever point you would like to read it in, that's up to you.
Your Honor.
Yes, the plaintiffs would call constructively Sylvia Scott to the stand.
Just push on it.
Yeah. Your Honor, may I approach the witness with a copy of the transcript for the reading? Yes. May I proceed? Yeah. Line 4. Good morning. Please state your name for the record.
Sylvia Scott.
Line 14. What do you do for a living?
I'm a junior high teacher. I teach English
How long have you been doing that?
for about 8 years.
How old are you, Miss Scott?
33 years old.
And how old were you when you met Ryan?
I met in high school. We were high school sweethearts.
72. I want to talk about that more in a bit, but first, when did he start working for Spyglass Vista Apartments?
Maybe in 2020.
Did he ever say why he wanted to work there?
No, it was just a security job.
As far as you were aware, was he concerned about working there?
Not at all. He had been there for 3 years, and I didn't get the idea that it was any worse than any of the other jobs he had done for the police. I never heard anything about a shooting or any kind while he was working there. It was mostly like cars being broken into and some suspected drug activity. That's what he.
You had mentioned earlier that you had moved out at some point. When was this?
About a year before he died.
I'm free. Question, what were the fights about?
He worked at the apartment complex, and I got tired of it. So he was either asleep or drinking during the day, and I felt like he was picking a fight.
I just had enough. I couldn't take care of both of us and I moved out for a while.
Did you ever talk about divorce?
No, the way he was raised, divorce was never an option in his mind.
How long did this last?
Well, about 6 months before he was shot, we started connecting again. We actually started going on dates again on his nights off. It was really nice.
Did you move back in with him?
No, but we had been talking about it, like literally the month before he died.
I want to talk to you about July 19th, 2023,
Okay.
1:37. When did you hear about what happened to him?
That evening, the police called me down to the station because I'm his wife. I had to identify the body.
And did you do so?
Yeah.
Tell me what it's been like after he passed.
It's been really hard for a while. We had been together forever. Even when I moved out, we really never lost touch. I just needed some time to figure things out. Like I had said, we were starting to see each other more often again. We had plans that night to go out to our favorite Italian food restaurant with some friends. I really thought we were going to move back in together. Everything was going to be all right.
166. You said it was hard for a while after he passed. Did you ever see any medical professional or therapist or anyone like that to help you with Ryan's passing?
No, I thought about it, but the school year then started shortly after, so I just buried myself in teaching my students. I didn't know what else to do.
No further questions.
Would you like the question to witnesses at the point?
Yes,
You may proceed.
Your Honor, would you like a copy of the transcript as well as the presentations?
That's not necessary at this point, but thank you.
And you know, we have our witness. All right, we give a transcript. Permission to proceed.
You may proceed.
Starting at line 57, was he a police officer at the time he was shot? No, he had gotten let go about 3 years before that, so he was working security for an apartment complex. Do you know why he was let go? It had something to do with a drug investigation he was working on. I think he was there. I think there was some allegation that alcohol and his temper had something to do with it. I don't know. He wouldn't really talk to me about it. Ultimately, I think he was given the opportunity to resign instead of having the whole thing blow up in his face. So that's what he did. Did he immediately transition into the security guard work? No, I think he was depressed for a bit. He started drinking and we started getting into fights. I even moved out for a while. Jumping to line 93. What were the fights about? He worked nights at the apartment complex and I got tired of it. So he was either asleep or drinking during the day and just felt like he was picking fights. I had just had enough. I couldn't take care of both of us, so I moved out for a while. Jumping to line 106. Did you move back in with him? No, but we had been talking about it like literally the month before he died. Jumping to line 154. Is that your Twitter handle, Sylvie Sweetshot? I'm sorry, what line? 154. Okay. Yes. Your Honor, permission to publish to the jury what's already been admitted as the tweet.
Any objection?
No objections, Your Honor. This exhibit has been pretty good.
You may proceed.
Thank you, Your Honor. And it's dated March 23rd, 2023. Yeah, I remember this. You posted, "Okay, girls, I need Rex for the best internet dating sites because I'm getting really tired of this crap." Yeah, we had started dating again, but gotten into a fight about something stupid. So I posted that, but I never did anything about it. He called me like the next day to apologize, but about whatever he thought about. Jumping to line 102, how long did this last? 102? Yes, line 102. Well, about 6 months before he was shot, we started connecting again. We actually started going on dates again on his nights off. It was really nice.
Did you move back in with him?
No, but we had been talking about it like literally the month before he died.
No further questions. Yes, Your Honor. Plaintiffs would like to call Officer Andy Rubenstein. And also, Your Honor, we have a matter that we would like to take up with the court regarding motion in limine that this court has already determined. The line of questioning that I anticipate this witness will discuss goes into one of the motions in limine. So I'm asking the judge, would you like to address those issues before the witness takes the stand or as the questions lead us there?
As the question is.
Yes, Your Honor, understand.
Please raise your right hand. Swear or affirm that the testimony you're to give this cause will be the truth at the whole truth and nothing but the truth. Please have a seat. You can receive.
Please state your name for the record.
Andrew Rubenstein, I go by Andy.
And why are you here today?
I guess to talk about what happened to Mr. Scott.
So what is your involvement with what happened to Mr. Scott?
I was with my partner, Mr. David Gans, and we were in the scene. We were called on the scene.
Now, you said you were with your partner and will you please tell the court today, what do you do for a living?
I'm with the Houston Police Department.
And how long have you been with the Houston Police Department?
11 years.
And did you receive training before you started the police department?
Yes, I was at the academy for 2 years before my 11 years.
Your Honor, I'm gonna have to object. I'm not sure what this witness is looking at. Is that see what it is he's looking at?
I'm looking at myself, it's a camera.
Oh, okay. My apologies.
So I'm recording, so when it's we literally see.
And that's what I looked down at also because
Yeah.
recording me as well, so.
Officer Riverside, how long have you been an officer? I'm not sure.
11 years.
And can you describe what your day-to-day looks like as an officer?
Yeah, so I'm on the North Side Patrol Division, and I'm part of the Crime Suppression Unit. Our job is to reactive, analytically find techniques to basically prevent crime.
Your Honor, may we approach the bench?
Yes. How about we do it constructively?
Constructively.
Yeah.
Your Honor, the line of testimony that I believe is about to come up is going to go into the specific area in Northside Houston for which this officer has direct knowledge of. This area is called Crime Row. One of the materials that has helped this expert and I stand that it will be very helpful for the jury to understand more of a picture of where Spyglass Vistas is in Northside Houston, because that is a very broad area. However, Crime Row involves 5 apartment complexes, including Spyglass Vista apartment complex, When this officer is patrolling and surveying for crime, he is doing it in Crime Row specifically. He's not necessarily going all throughout North Side because most of the crime occurs in Crime Row.
Response.
Your Honor, may the jury be constructively removed and disregarded and be instructed to disregard any reference to crime rep?
Everything's been constructed.
Thank you, Your Honor. So I'm going to reiterate that we object under 403 again. We have no problem with opposing counsel describing the area and the concentration of crime. However, to label it as Crime Row, we find that it's substantially outweighed by the unfair prejudice of allowing this jury to believe that the name of this area was called Crime Row.
Response, Your Honor.
Yes.
Your Honor, this is exactly what the officer would call the area if he's ever patrolling. If he's ever talking to his partner, Officer Gauntz, he's gonna say, hey man, we have to go meet at Crime Row. He's not gonna say we need to meet at this part of Northside Houston. This goes specifically into his day-to-day. And the prejudicial value of simply saying Crime Row can be easily lessened by opposing counsel should they have any kind of evidence indicating that Spyglass Vista's apartment doesn't constitute the negatives that are allegedly coming in with Crime Row. And additionally, the probative value of this is significant. This jury needs to understand a full picture of what was going on at Spyglass Vista's apartment. And one of the essential elements for our case today is the knowledge that Spyglass had. Not just the actual knowledge, but the constructive knowledge, which is based on the area, the Crime Row area.
I will allow the line of question, and I will allow the use of the term crime row.
Thank you, Your Honor. May we be constructively let back in. Officer Rubenstein, will you please share with the court what you are looking for when you're patrolling in Northside Houston?
Northside Houston, we're looking for drug activity, prostitution, domestic violence, things of that nature.
And does that lead you anywhere specifically?
Yes, so there's an area that we call Crime Row. It's 5 apartments and a 2-3 block radius in the north side.
Your Honor, may I approach the witness and present what has been previously marked as Exhibit 40?
Yes.
I asked to present it to the jury. Thanks. Officer Rubenstein, do you recognize what I've just handed you?
I do.
And how do you recognize this?
It's a map of I drew a Crime Row area.
And can you tell the court a little bit more about what we are seeing in this depiction?
We're seeing 5 apartments that are in the 2 block radius, which makes up the Crime Row area.
Now, I want to know a little bit more about what brought you here today. What were you doing on July 19th, 2023?
As I mentioned before, I was with my partner, Mr. David Gantz. We were responding to a domestic violence call that was at Shadow Lark Apartments, as you see on this picture.
Is that in the top left of this depiction?
Yes.
And what was that call for?
Domestic violence in an apartment building room.
And that domestic violence was where at again?
Shadow Lark.
And can you share a little bit more about what happened next after you were called for that domestic violence call?
Yeah, so we knocked on the door of the room, apartment building room that was said to have domestic violence. No one answered. The neighbor, there was a kid that opened his door and let us know that that couple left as soon as they heard the cops were coming. So my partner and I walked back to our car, kind of just staked out the area to see if there's anything else that could be going on. Maybe the couple would come back. And then that's when we got the call. There was a shooting just down the road.
And can you share a little bit more about what the shooting was?
So the shooting was at Spyglass Vista Apartments. So we took the call since we were just 2 blocks away and we were in the area. We could get there quicker than anybody.
And so you were on that, you left that domestic violence call to go to the shooting?
Correct.
And can you explain a little bit more as to why you did that?
Just because shots were being fired, man down. So we thought it was more important to be in that situation.
And so did you ever make it to Spyglass Vista Apartments?
Yes, we made it, I think 2 minutes from receiving the call.
So once you got there, what did you see?
First things we saw was a hysterical Hispanic woman was over a Caucasian man. She had clothes wrapped around, looked like the spot where he was shot. She was covered in blood as well. Another woman was approaching as this was going on as well.
And did you learn anything about who this other woman was?
The other one we found out as we came up and talked to them was Miss Casey Hayden, the manager of the apartment.
Of which apartment?
Of Spyglass, sorry.
And you said a man was laying down. Can you describe that a little bit for the jury today?
A man was shot twice in the chest and 1 through the leg.
And did you notice anything else about this man?
At first, no, but I did notice he looked familiar as the closer I got to him for the scene.
And how did he look familiar to you?
I identified him as Mr. Scott. I went to academy with him. We overlapped a little bit. As I was graduating, he was kind of beginning. And then over the years, responding to calls at Spyglass Vista, I'd meet up with him on certain calls. So
When you say you would meet up with him, can you kind of elaborate on what that means?
typically in Spyglass Vista, break-ins, so domestic charges, and if he was the security guard on site at that time, then I would deal with him.
So just so that we're all on the same understanding, whenever you and Mr. Ryan Scott would engage at Spyglass Vista's apartments, what role were each of y'all in?
So he was the security guard and I was the police officer.
Now, back to the day of the incident, you said there was a woman outside of the security manager and outside of the man who was laying on the ground. You said there was a woman who was covered in blood. Can you share a little bit more about your interactions with that woman?
Yeah, so as we approached, the EMTs were already there on the scene. So I had my partner, Mr. Gantz, enclose the perimeter, and that's when I took the woman who now is identified as Miss Gomez, Alicia Gomez. I took her over to, I think it was a curb, a little bit away from the side of the crime, and asked her some questions.
And where did that lead you next on your investigation?
So that led me, she talked about it was a dispute that began with her fiance.
Objection, hearsay.
Response?
Yes, Your Honor. This is an exception for the effect of the listener. I am merely asking what this officer did based on the investigation. I'm not offering the statement for the truth of the matter asserted.
Your Honor, this witness has been asked to elicit statements from another person who's not in this courtroom. We believe that they will be using these statements to prove the truth of the matter, so unless it is hearsay.
Anything further?
Yes, Your Honor. I'm not asking him to recount what another individual said. I'm merely asking him what, if anything, with his interactions with Alicia Gomez influenced his investigation as the investigating officer in this matter.
The objection is sustained and the officer can answer without detailing what was said.
What, if anything, based on your interactions with Alicia Gomez, influence your investigation at the scene?
Can you repeat that, sorry?
What, if anything, did Alicia Gomez do to assist or influence your scene investigation on the day of the incident?
So after questioning her, she asked if she could change. And, she was covered in blood and she said she lived in the apartment complex. So I let her. And yeah, that's where it began.
Where did she go next?
Presumably to her apartment building.
What did you do next?
So as we were waiting, my partner was, questioning, Miss Hayden. And that's when it's been some time, so we're like, we have Miss Hayden with us, so we said we go to see if Miss Gomez is in her room. So we went to her apartment room.
And what did you find when you went to her apartment room, if you found anything?
So we knocked, no answer. Miss Hayden had the key, so we opened, and when we opened the door, it looked like someone had hurriedly grabbing things, with things all over. We did see some 5 pounds of marijuana, baggies, electric scale, some coke residue. There was no money though.
And did you learn about if anyone else lived with Alicia Gomez?
And so this is back to when we first questioned her, but that was when we introduced to Mr. Goss, which is who her fiance was, and part of the dispute with Mr. Scott was with Mr. Goss.
No further questions, Your Honor.
Council Cristen.
Yes, Your Honor. Officer Layrisson, you testified that the area in which the Spyglass Vista apartment sits in is labeled Crime Row. Is that correct?
That area is, yes.
And you're actually holding that map. And nowhere on there does it say Crime Row, does it?
It doesn't.
None of the streets are named Crime Row.
Nope.
Now, out of all 5 of those complexes, Spyglass Vista had the fewest incidents, correct?
I don't know off the top of my head.
You don't know at the top of your head if Spyglass Vista had the fewest amount of,
Yeah, I don't know how to identify which apartments. We just kind of patrol that whole area. So wherever we get calls is where we go.
now, you patrol all 5 complexes, correct?
Yep.
Not just Spyglass Vista.
Yep.
Now, I want to talk about Morris Gus. Morris Gus was the person who shot Flanagan, correct?
That is what we that is what the testimony said.
And there's an outstanding arrest for Mr. Gus, true?
Yep, true.
And to this day, Morris Gus has never been found.
No, also.
Now, Alicia Gomez, the woman who lived with Morris Gus, she had never seen Morris Gus carry a gun, correct?
That's what she knew that he had guns, but she did not never see him. She didn't know that he carried it on the desk.
And that's in your report, correct?
Correct.
So even the person closest to him didn't know he was going to carry the gun, and Ron stopped that day.
That's correct.
Now, I want to talk about the prior domestic violence call. You're aware that there was a prior domestic call at Spyglass Vista, correct?
Yeah, after going to the scene, and when you look at everything, we saw that we did realize that there was a call from them.
And that involved Mr. Morris Gus and Alicia Gomez,
Correct, yeah.
and that call resulted in no arrest,
Yeah, no charges were pressed,
and nobody was injured,
no injuries,
and the police responded and left without incident.
I guess.
So, Morris Gus wasn't found with the gun at that time, correct?
No.
I want to talk about Mr. Scott for a little bit. Mr. Scott was no longer an employee of Spyglass Vista, true?
Yes, that's true.
He had been fired earlier that day,
Yeah, from my understanding, yes.
and so he wasn't acting in any official capacity for Spyglass Vista.
Not at that time.
And on the day of the shooting, he decided to come to the apartment on his own will, true?
From the reports, yes.
And nobody from Spyglass Vista told him to return.
Objection, hearsay.
Your Honor, this information is included in this witness's report, which was discussed on direct examination. Thus, this witness should be allowed to testify about the events included in his report.
Response.
Yes.
She is specifically asking what two individual people outside of Mr. Officer Rubenstein discussed and what the statements were that they discussed.
Your Honor, that was not the question. The question was nobody from Spyglass Vista directed Mr. Scott to come back to the complex. I'm not asking for a statement.
Response, Your Honor. Briefly. The direction that Spyglass Vistas would provide would necessarily be in a statement. Merely saying direction instead of what did they tell you should not skirt the rules of hearsay.
I'm gonna overrule that objection.
Can you repeat the question?
Nobody from Spyglass Vista directed Mr. Scott to come back to the complex, correct?
I wouldn't know what was directed at Mr. Scott, but presumably no.
Well, according to Ms. Gomez's statement in your report, Mr. Scott approached Morris Scott, correct?
Yes, as the dispute was going on.
And you're aware that Mr. Scott called Mr. Gus a derogatory term.
Correct. There was yelling involved, both sides.
Now, as an officer, you'd agree with me that that language, calling someone that name, that's the kind of language that can inflame an already tense situation, true?
That's true.
And you received the escalation training, correct?
Correct.
And Mr. Scott, he also took the same training as you, right?
Since he was in the academy, yes, I would say so.
So he would have been aware of the same de-escalation training that you received, right?
He should be. Yeah.
Now, I want to talk about Spyglass Vista and what steps they took. Spyglass Vista hired security guards after they told them to be journalists, correct?
Yes.
And they had security cameras in parking lots,
Yes.
and they had security guards patrolling the area,
Yes.
and that was every.
Every night.
And you'd agree with me that the car break-ins went down significantly after those security guards were there.
From my perspective, I think so. Yeah.
Now, you yourself saw Mr. Scott working at Spyglass Vista, correct?
So often if there was a call there and he happened to be working, yes.
And you saw him because you were patrolling that area, true?
That or if we're responding to a call there.
And so security presence was visible and known to the community, right?
Yes.
And so you agree with me that Spyglass Vista took some steps
Yes.
to address the crime on the property,
I'd
correct?
say so, yes.
Officer Rubenstein, in your years of experience, you've seen crimes committed by individuals who gave little to no warning beforehand, correct?
Yes.
And it would be unfair to hold a business responsible every time a violent criminal who happens to live on the property that commits an act of violence. It would be unfair, correct?
In the crime in rural areas, yes, I'd say.
And ultimately, the person responsible for shooting, or let me rephrase, Mr. Scott is dead because Mr. Gus pulled the trigger and shot him, right?
Yes.
Not just once, but 3 times, correct?
2 in the chest, 1, I guess.
No further questions for this witness.
Redirection.
Yes, Your Honor.
Officer Rubenstein, in your experience, do you see a successful conviction with every crime committed?
No.
Now, on the previous depiction of the area, including Spyglass Vista's apartments, can you explain to the court why, if at all, you decided to leave out Crime Row from your depiction?
It's just, our police department calls it Crime Row, locals call it Crime Row. It's pretty known.
No further questions, Your Honor. Made away, please.
Yes, you may sit down. Plaintiff, please call your next witness. Yes, Your Honor, plans all, Ms. Brewster's. Raise your right hand. Sorry. Feel good. Do you swear or affirm that the testimony you're to give in this cause will be the truth, the whole truth, and nothing but the truth? Yes. Please have a seat.
Your Honor, our, this witness is also our timekeeper, so I'm going to request her to say no.
No, not this round, it's Colin.
Your Honor, we can strike that from the record. Good morning, please say your name for the record.
Good morning, everybody. If you have trouble hearing me, please let me know. I just, for some reason, allergies are kicking in. My name is Drew Simmons.
Ms. Simmons, what do you do for a living?
I manage a bunch of properties all over the state, but I also own Simmons Consulting. I also currently own and operate Simmons Consulting.
Will you tell us a little bit about what Simmons Consulting is?
Yes, so with Simmons Consulting, what we do is we will audit, evaluate, and consult on premise and premise securities. And normally we do everything from evaluating risk or dangers, as well as any other measures that they ask us on those properties.
Have you, does this include security audits for multifamily properties?
Yeah, so we do all types of properties, but more specifically, multifamily property, more like apartments are actually our primary types.
How long have you worked in the field of security management?
For about 15 years now.
Why don't you tell us a little bit about your education?
Yes, so I'm a Red Raider. That means I went to Texas Tech back in graduated in 99. I graduated with my bachelor's in science in criminal science, and I graduated summa cum laude.
Ms. Simmons, what kind of, if any, professional certifications do you hold?
Yeah, so I am board certified through ASIS International, where I hold a, where I'm certified as a security management, I'm certified in security management. I hold a CFF, which is a, CPF, Certified Protection Professional. Certified Protection Professional, that's what it's called. It sounds like a big fancy word, but all it is just, it's designated to those and only those who have showed a high competency in security management. It is a very well-known designation in our field.
So aside from these certifications, are you involved in any professional, what kind, if any, professional organizations are you involved with in this field?
Yes, so I'm a member of ASIS International. I am a member of the Institute for Real Estate Management, and as well as a member of the National Real Estate Association.
Does that mean you're involved in real estate as well?
I'm involved in real estate all over, whether it's managing or consulting.
So back to your security audits, what kind of security issues are you looking for when you conduct these audits?
So it depends on exactly what they're asking us to look at, but more specifically, we look at what kind of risks will be present or could occur on the property.
Ms. Simmons, have you previously been designated as an expert in depositions or trial?
I have multiple times.
And have you testified previously in any depositions or at trial?
Yes, I have.
Ms. Simmons, based on your education you've shared with us, your training, your experience, and your certifications, do you have specialized knowledge in criminal foreseeability regarding apartment security?
Yes, I do.
Ms. Simmons, excuse me, contagious allergies. Were you asked to analyze issues involved in this case?
Yes, I was. So I was asked to analyze 2 questions. It's going to sound like 3, but it's only 2. First question is going to be whether there was any dangers or risks associated with the property. And if there were present, then whether they failed to warn any invitee, including Mr. Scott, of those dangers? And second was whether they, second question was whether they took any measures to prevent those.
What materials did you review to develop your opinions?
So I reviewed everything that was provided provided to me, and that was going to be the depositions, including the deposition for Ms. Scott, Officer Rubenstein's, and Casey Hayden's, as well as any police reports that were attached to the file, any exhibits, and any data that I was able to collect regarding crime in the area.
What kind of data were you able to collect, if any?
So I was able to collect data from the constable's office here in Houston County, here in Harris County, where I was able to retrieve the violent crimes that occurred throughout the entire county, as well as in specific areas.
Are these materials that are reasonably relied on by professionals in your field?
Yes, they are.
So throughout, to develop your opinions, did you use a methodology that is typically relied on by professionals in your field?
Yes, I did.
Will you describe that methodology briefly for us?
Yes, so we pull all that crime data that I was talking about, that I was talking about, but we also apply the principles that we are taught in the community, but also any patterns of crimes that could occur. So we take all that together and we go to analysis to decide whether we can answer those questions.
And did you rely on these methods? Did you apply these methods reliably to the facts of this case as they were presented to you?
Yes, I did.
And were your opinions formed in this case based on a reasonable degree of professional certainty?
They always are.
Your Honor, at this time, the plaintiff offers Ms. Simmons as an expert in premises security management and security standards.
No.
Witnesses, note as an expert.
Your Honor, this expert's report has been previously admitted as agreed on by the parties. May I approach the witness and present her with her report and have it on hand?
Yes.
Your Honor, may I present a copy to the jury as well?
Yes.
I apologize, Your Honor, if I gave away. Ms. Simmons, did you form an opinion on whether criminal violence was foreseeable at Spyglass Vista Apartments on the day Ryan Scott was killed?
I did.
And what facts did you review? What facts did you learn that supported your opinion?
So my ultimate opinion here would have been that it was foreseeable, but not only was it foreseeable, but it was also preventable. And to get there, what I did is I used as you can see in this report, I used the violent crime numbers. I also used any information that I was able to obtain through an evaluation of the property. And that included finding out that there was a drug bust in 2019, as well as all the information that was provided.
You mentioned crimes. You mentioned violent crimes. Will you tell us what are considered violent crimes?
Yes. So violent crimes are not just all types of crimes. More specifically, they would include rape, sexual assault, theft, robbery, and murder.
According to who?
That's going to be, I believe, it's to the Harris County. Harris County.
Looks like the report says the Harris County Constable's Office.
That is correct, yes. Correct. Yes. All this information on here was directly from the Harris County Constable's Office.
So why don't you tell us a little bit about these statistics that we're looking at here in this table on page 2 of your report?
Yeah, so as you can see, in Harris County, the average amount of violent crimes in 2022 being the year previous to this incident, is about 11.3. And more specifically in this area, you can see that every single apartment complex, including Spyglass Vista, are way outside of that. And in some cases up to 5 times.
These are, these statistics we're looking at here, these are from 1 year prior to the accident in question here today, right?
That is correct.
Are these the apartments we, Ms. Hayden, have you been sitting in here with us throughout testimony? Sorry, Ms. Simmons, have you been sitting in here with us throughout testimony so far this morning?
Yeah.
So you saw the map that Mr. Officer Rubenstein spoke with us about? And are these the same apartments that were depicted on that map?
Every single one of them.
Ms. Simmons, you're aware that the parties stipulated as to the number of apartments, the number of units in the apartments on Crime Row?
I did. I am, excuse me.
Your Honor, may I approach the witness and present with her our stipulated information that to refresh her memory?
No objection.
Yes. Your Honor, may I also present a copy to the jury?
Objection, Your Honor. She hasn't laid the foundation for this to be admitted as an exhibit.
Your Honor, I will do so. May I still approach my witness? All right, Ms. Simmons, do you recall reviewing this information as part of your audit?
I did.
And what information have I just presented you with here?
You presented the amount of units for these 5 apartment complexes.
And where does Spyglass Vista rank on this list as far as number of units goes?
It is the smallest of the 5.
Does that mean it has the fewest number of units?
Yes, correct.
How many units does Spyglass Vista Apartments have according to this list?
176.
And what is the next closest number of units?
It's almost about double, 330.
What is the largest apartment complex on Crime Row according to this list?
That's going to be Silver Rushing Apartments.
How many units do they have?
561.
So proportionally, Spyglass Vista Apartments is the smallest of all of the properties on Crime Row.
That is correct.
I'm going to refer you back to your report here. In 2022, Spyglass Vista had nearly, we discussed Spyglass Vista had nearly double the amount of violent crimes as average in Harris County.
Objection, Your Honor, meeting.
Albert Reyes. Ms. Simmons, what is, how does Spyglass Vista Apartments 2022 violent crime numbers relate, compared to the Harris County average?
So as you see from the report, the average in Harris County is 11. And if you were to go right above that, you would see Spyglass Vista Apartments. You can see that that's 21. That is almost double the amount of the average you will see in Harris County on average.
And based on the proportions that we just, the size comparison of the apartments that we just reviewed from Crime Row, how would you say the crime numbers in these 2022 lists compares overall based on the size proportions?
I mean, it's very proportional.
All right, let's move on here. Why don't we talk about the police raids, the previous police activity on the property? What can you tell us about any previous police activity on the property?
Other than like break-ins that happen periodically, there was a big drug bust that happened in 2019. And this big drug bust, they were able to recover about 10 pounds of cocaine and about 20 pounds of marijuana.
Where'd you obtain your information on this drug bust?
So I was able to get that information from the apartment complexes, but this is also public knowledge. Anybody can look this up.
What did you learn, if anything, during your audit about how the complex responded to this bust?
So it looks like to respond to the drug bust, they added some security cameras and some security guard in it.
What was the extent of the security guards, security patrol that they added?
Looks like the patrol would only, the security guards would only patrol at night. I believe from 9 p.m. to about 6 a.m.
What, if anything, did you learn during your audit about Mr. Morris Goss and Miss Alicia Gomez?
It looks like they were both tenants at the apartment complex. Looks like they could have been involved in some sort of drug activity.
And why, if so, are those facts significant from a security manager?
Well, there's a high correlation between drug activity and violent crimes.
Will you tell us a little bit about that?
Yes, so whenever you're dealing with any type of drug activity, normally you're going to see a few things there. You're going to see one, that there will be a type of person that gets involved in drug activity. Second, you will see that there's a large amount of money that is included in that drug activity. And third, you will also see that the narcotics themselves are involved in that. And when you look at that as a whole, there's a high correlation between the drug activity and the violent crimes.
In your opinion, should management have recognized the risks surrounding tenants, these two tenants, based on this knowledge that they had?
Yes, definitely.
In your opinion, was the shooting that led to the death of Mr. Ryan Scott preventable?
It's foreseeable and it was preventable.
And briefly, why do you say that?
Well, they knew of the dangers that existed, or at least they should have known. And they did nothing about it, or they didn't take reasonable steps at least.
Do you have an opinion on whether the defendant's Spyglass Vista Apartments failed to make the premises reasonably safe?
I'm sorry,
Do you have an opinion on whether, did you form an opinion on whether the defendant's Spyglass Vista Apartments failed to make the premises reasonably safe?
Yes, they failed to do so.
And are these opinions held with a reasonable degree of professional certainty?
Yes, they are.
No further questions from me.
Cross-examination.
You're a certified protection professional, correct?
Yes.
And the majority of the time that you have been retained as an expert has been for the plaintiff side, correct?
I'm sorry, did you say the majority of the time?
Yes.
Yes, we can say that.
You're not a criminologist, right?
I don't even know what criminologist is.
You're not a law enforcement officer, correct?
Oh, no.
And let's talk about your investigation of this case. You never visited Spyglass Vista physically, correct? You never interviewed not one member of Spyglass Vista's staff, correct?
That is correct.
You never interviewed not one tenant of Spyglass Vista, correct?
Personally,
Personally, in any form, written. You mentioned the 2019 drug bust, correct?
yes, I did.
You relied on that to form your expert opinion, correct?
Correct.
And you would agree with me that that was 4 years before this accident, correct?
Yes.
And you would also agree with me that conditions can change between 4 years, correct?
Yes.
Now, due to this 2019 drug bust, Spyglass Vista hired security guards, correct?
Yes. Yes, I did.
And Spyglass Vista then took steps to approach this incident, correct?
They took some steps, yes.
Now, let's talk about your opinion about Morris Gus and Alicia Gomez. Your testimony was based on what a security officer told Spyglass Vista, correct?
Yes.
Now, you never interviewed that security officer, correct?
That is correct.
No police or law enforcement were retained in regards to this suspicion, correct?
He was a DEA agent, but outside of him,
Jason Mitchell, the security guard that informed Spyglass Vista, was not a DEA when he informed that suspicion, correct?
at the time, you are correct.
So Spyglass Vista hired security guards, correct?
Yes, they did.
That is recognized as a security measure, right?
That is a security measure they said they took. Yes.
You cannot sit here and tell the jury what specific measure would have prevented Mr. Ryan Scott's death, correct?
Well, the question I was asked wasn't what specific measures I should take. The question that asked was whether there was a risk or danger on the premises.
I'm
That's
gonna-
what I answered. No, sorry, excuse me.
You're finished?
Yes, sir.
I'm going to repeat my question.
Mhm.
You cannot sit here and tell the jury what specific measures caused the death of Ryan Scott, correct?
What specifically caused, I just want to try to understand this. I'm sorry, maybe I didn't get that correctly. What specifically caused his death?
Correct.
It was the shooting. Morris shot him, and that's what caused his death.
Well, you cannot tell this jury what warnings would have prevented Ryan Scott from getting shot by Morris Gus, correct?
I possibly could, but that's not what was asked of me in this report.
No further questions. Thank you.
Redirect? Briefly, Your Honor. Ms. Simmons, between 2019 and the time Mr. Scott's death in 2023, what is your opinion? What is your opinion on whether those conditions, those security conditions changed?
So one more time for me, please.
So between 2019, on cross, we heard testimony about any potential changes in safety conditions on the premises within the 4-year time period. What is your opinion on whether there was a change in safety conditions on the premises?
Well, there's no doubt that there was a change, but it's not a reason to change.
No further questions, Your Honor.
No request.
You may sit down. I can please call your next witness.
Your Honor, plan express its case in chief. Do we need to take up any motions before we take a brief break?
Yes, Your Honor. Thank you. Like to make a motion outside the presence of the jury. Need the jury be constructively excused?
Everybody.
Your Honor, at this time, the defendant would like to move forward a directed verdict. Under the Texas Rule of Civil Procedures 268, the defense has not laid legally sufficient evidence to prove one or more of their claims of negligence, specifically that the condition on the premises posed an unreasonable risk of harm, and secondly, Your Honor, that any negligence of Spyglass Vista was the proximate cause of Mr. Ryan Scott's death.
Response.
Yes, Your Honor. We heard testimony today from an expert who specifically said that she connected the dots between drug occurrences and violence. She just testified that there is a high correlation between violent acts and drugs. We also heard several lines of testimony where we know there was some kind of drug activity going on at Spyglass Vistas. In 2019, they had a huge bust. That and all of the violence that we know from our last expert is correlated, is enough to show the unreasonable, dangerous condition upon Spyglass Vistas apartment complex. And because Spyglass Vista did not do anything to either warn Mr. Scott or to protect him, it cost him his life. Anything further?
No.
The motion for directed verdict is denied. We're gonna take a brief break.
Take my notes.
I've been trying to look at your notes.
I know, I'm actually looking at.
Perfect. Just the basis. I don't want to throw it out the toss. Tax relationship.
Yeah. On the board. Yeah. Because she, I wanted to do it, kept alone, I'll be like, you could have asked me this in my deposition, and now we're ready to give me this information. Because he's asking me a question that I've never been. Sorry, buddy.
Why?
No,
Oh, you did great.
you did great.
You did great. What's your name?
I'm Genevieve.
Genevieve.
Yes.
Enrique. Yes.
Oh, you're practicing.
You know, a year and a half.
We're two of us.
Oh, you're kidding.
Yeah.
Well, I'm still struggling with my office in the States.
Oh, since day one for me, I'm not working also. I'm like, why am I in law school? What's going on? Why do I hate myself?
Yeah. But this is such a great experience. Really nice. I didn't want to.
Yeah, we're all in the law club.
Sweet. Sweet. It's a good practice. Once you start practicing, this is you see this like a little bit.
Yeah, I can see that. Sometimes we go and like which says Watchroad Drive. A lot of people are trial attorneys. So they'll be like, hey, go watch the trial. And it's crazy how the judge can affect the entire comment.
Oh, yeah.
Because if you didn't have a judge that is little tights and everybody was little children, like there's all the judge definitely says. It's one of those, it's gonna watch this. I can't wait. Okay, go there. Can't wait.
So around there, we have even an attic.
Hey, you're doing a lot of stuff, John. Thank you.
Oh, my life. Oh, the license. Oh, driver's
Yeah.
So just one.
You brought it play back one more.
Yeah.
My best friend's gonna take me. Yeah.
What it's supposed to do.
Oh, yeah. This is great.
I just.
Yeah, that's because you're saying. Well, what you do is you talk about. Presumably he brought it on the plaintiff's hair.
That's why I do it. Very good.
Then you all be
Yeah.
So everything you've done. He's like, you also need to. Is this this or is it?
Perfect, thank you guys. Yeah.
This is
Somebody where you're saying.
Yeah.
Oh,
Yeah.
Oxymoron, say free.
It was also like.
All rise for the jury. Bailiff job.
I love it.
Oh, that's good, yeah. How many rings are there? Yeah, it's a lot. Yeah, that's fine.
Yes.
Everyone can be seated. Next, ready to proceed. Defense ready to proceed by calling the first witness.
Yes, Your Honor.
Yes.
So he is this one.
An extra pen, I left mine in there.
Yeah.
Please read the
Which may or may not
Do you
work.
swear or affirm that the testimony you're to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Please have a seat. Good afternoon. State your name for the record.
Hello, my name is Casey Hayden. Ms. Hayden, what do you do for a living?
I'm the property manager at Sky Vista.
What does your role consist of?
So, I mean, it could mean to just managing the property, looking at leasing applications, and even overseeing security, like hiring security personnel.
And you just mentioned security personnel. Who do you hire for the security personnel?
So I typically hire the best of the best, I mean, law enforcement.
Now, I want to move to Spyglass Vista. Why did Spyglass Vista hire security guards to begin with?
So unfortunately, in 2019, we did have a drug bust at one of our apartments. And so, I mean, that was a wake-up call for us. And so that's what prompted me to contact ownership, and they gave me permission to go ahead and hire security.
So what did those security guards do?
So they oversaw the property at night and looked through camera footage. We had cameras installed in the parking lots within our property. And yeah, just made sure that the complex was safe.
And Ms. Hayden, in your opinion, did those security or those measures make a difference at all?
A significant difference. Before 2020, when I hired them, we would have like 5 to 6 car break-ins a year, and that number dropped down to 1 to 2.
Now, did you train these security guards?
No, I left it to the professionals. They had their law enforcement training.
Now, why did you specifically hire former law enforcement personnel?
I mean, they had come already trained with the best training. So
now, how did you come to hire, or did you hire Mr. Ryan Scott?
I did.
And how did you come about doing that?
So I had some contacts in law enforcement, and through word of mouth, he sounded like a solid guy. And then I went on and ran a background check, and nothing came back negative, so hired him.
Your Honor, permission to approach?
Yes.
I'm showing opposing counsel was Lee marked as defendant's exhibit 2. Your Honor, would you like a copy?
I don't think.
I'm now handing the witness, Ms. Lee marked as defendant's exhibit 2. Ms. Hayden, do you recognize this document?
Yes.
And what is it?
This is the employee file of Ryan Scott that I drafted.
And were these entries made at or near the time each event occurred?
Yes, I mean, it's important for me to have these occurrences documented, you know, within that time frame, just so I could get all the details right.
And was this record kept in regularly conducted business activities at Spyglass Vista Apartments?
Yes, as property manager, I want to make sure that the employees that we have are behaving well, and, you know, just making sure that if there's any documented patterns, we can address them further.
Thank you, Ms. Hayden. At this time, Your Honor, defendants offer exhibit 2 into evidence.
Your Honor, I believe that this. Yeah, well, it wasn't this pre-admitted?
Your Honor, it wasn't pre-admitted.
Do you have an objection to the evidence admission?
No, I do not.
Exhibit 2 is admitted.
Now, Ms. Hayden, without going through every entry of this file, what is the overall picture the file paints of Mr. Scott?
So, I mean, don't get me wrong, Mr. Scott was a hard worker, but he did have some issues. He would come in late, and there were some interactions with tenants that were a little sketchy. Some even involving him being drunk.
Can you tell the jury about some of those drinking complaints?
Yes, so I believe one occurred in May of 2023. A tenant had an interaction with Ryan, and he smelled alcohol and had glassy eyes and just displayed drunk behavior. Once I confronted Ryan about it, he denied it. And actually, the day of the shooting, he made another tenant feel uncomfortable. He was following him around the parking lot, and the tenant again said that he had glassy eyes, smelled of alcohol, and was unsteady.
Your Honor, permission to publish to the jury. Now, Ms. Hayden, was there also a complaint from a tenant named Alicia Gomez?
Yes, in February of 2023, she had said that Ryan had come to her apartment saying or accusing that her guests were making too much noise.
And who is Alicia Gomez?
She is the girlfriend of Morris Goss, the guy that shot Ryan Scott.
Now, after the July 19th complaint about Ryan following that tenant to his apartment, what did you do?
I'm sorry, can you ask the question?
After the July 19th complaint about Ryan following the tenant to his apartment, what did you do?
So, I mean, that was the last straw that we had with Ryan. Ownership had already known about some of his recent behavior. And so I called ownership and they gave me the green light to go ahead and fire him. On that day, it was Ryan's day off. And so I gave him a phone call and I told him that he was terminated and gave him 2 weeks severance.
And how did Mr. Scott respond to this?
He was unhappy, but he understood over the phone. And that was that.
Now, did you hear from Mr. Scott after that initial phone call?
Objection, Your Honor, waiting.
Your Honor, if you'd like, I can repeat the question, but I don't believe this question is leading.
Okay.
Did you hear from Mr. Scott after that initial phone call?
Yes, at around 3 p.m., he had called me again. And he asked to get his job back. And I said that we could maybe discuss it further the next morning because honestly, he sounded drunk on the phone. I thought it would be best if he came in the next morning with more of a clear mind.
And how did Ryan react to that? Mr. Scott, how did Mr. Scott react to that?
He said, okay, and I thought I would be seeing him the next morning, so that was
Now,
that.
after that phone call, did you have any reason to expect that Mr. Scott was going to return to the property that day?
No, I mean, it had been his day off, and we agreed to meet the next morning, so absolutely not.
Ms. Hayden, I want to talk about Spyglass Vista. Before renting an apartment to Mr. Morris, Gus, and Alicia Gomez, did you guys do a background or screen them?
Yes, we always obviously want to make sure that we have, to the best of our ability, a safe apartment complex. And we unfortunately can't pick our tenants, but we can run background checks on them and, look at their income, look at their criminal background, look at their eviction history, and do our best to make sure that our complex is as safe as it can be.
Now, when you did screen them, did anything come up on these two?
No, nothing negative.
Now, before July 19th, did you know Mr. Gus had a gun?
I had no idea.
Ms. Hayden, had firearms ever been used at Spyglass Vista before the shooting?
Never.
Now, were you aware of any prior law enforcement call involving Mr. Gus and Alicia Gomez at your property?
Objection, Your Honor, the previous handful of questions have been leading.
Oh.
Yes, actually, there was a domestic violence dispute call. A neighbor of Mr. Goss and Ms. Gomez called, claiming there was some sort of domestic violence going on. However, Ms. Gomez came to me and said it was a misunderstanding and that she wasn't pressing any charges and no arrests were made.
Now, based on what you knew about that incident, what did it tell you about any future risk of violence?
I mean, domestic violence disputes seem, pretty internal, it's domestic for a reason. And so I didn't really think anything further would happen, especially a shooting in broad daylight outside of my office.
Now, before the shooting, did any of your security staff raise a concern about Mr. Gus or Alicia Gomez?
Yes, we had Mr. Jason Mitchell come to me and say that he had suspicion about some drug activity going on in Mr. Goss's apartment. And he was a former DEA agent.
Did Mr. Mitchell have any proof of this?
No.
Now, did you do anything, or what did you do with that information from Mr. Mitchell?
I mean, with this information coming from a DEA or previous DEA agent, and with him coming with foot traffic as proof and nothing otherwise, I didn't really expect to do anything. I would think that he would take matters into his own hands.
Now, did anything that Mr. Mitchell told you suggests that Mr. Gus was going to pull out a gun and shoot Mr. Scott in broad daylight?
I mean, drug activity is absolutely a concern, but that it was unpredictable for me to believe that a shooting would then occur.
Let's move to the day of the shooting. Where were you when the shooting occurred?
I was in my office when I was closing up for the day and I heard shouting outside.
And what did you see?
And I saw Mr. Goss and Ms. Gomez or they were arguing about something. And Mr. Goss then shoved Ms. Gomez to the ground. And that's when I saw Ryan and his blue truck pull up. And within seconds, that's when the tragedy happened.
Now, at that point, was Mr. Scott still an employee of Spyglass Vista?
No.
So what happened next?
So I saw Mr. Morris pull out a gun and shoot Ryan 3 times.
Now, from the moment you heard the shooting to the moment that you saw the altercation between Mr. Gus and Mrs. Gomez to the moment Mr. Scott was shot, how much time were we looking at?
I mean, it was a matter of seconds.
And did you have time to go out there and prevent this from happening?
Absolutely not.
And so what did you do?
I mean, I immediately called 911 and ran outside to make sure that, go outside and see what was going on.
Now, Ms. Hayden, did Spyglass Vista do anything that caused Morris Gus to pull out that gun?
No.
Did Spyglass Vista have any warning that Mr. Gus was going to pull out a gun?
No.
And in your 8 years at Spyglass Vista, had anything like this ever happened at your property?
Nothing like this.
Ms. Hayden, who is responsible for shooting Mr. Scott?
Morris Goss.
Thank you. No further questions at this time.
Cross-examination?
Yes, Your Honor. Ms. Hayden, you mentioned that you discussed on direct that you were under the impression Mr. Mitchell would take matters into his own hands. Is that correct?
I mean, as a former DEA agent, yes.
And taking matters into his own hands, would that mean an arrest?
I mean, I would think contact someone from the agency or something.
You are aware he was no longer a DEA agent, right?
Yes, I was aware.
Regarding the, Ms. Hayden, is it correct that you were in charge of implementing the policies and procedures, directing the security guards and their expected conduct on the job?
Yes.
You didn't have, but there was no, you didn't give them hard copies of any sort of official employee manual or anything, right?
No, I didn't feel the need to.
If Mr. Mitchell would, he would have no way of knowing that you expect him to take matters into his own hands unless you told him that, right?
No.
Did you ask him to handle the situation when he shared with you his concerns about Mr. Goss?
No, I trusted him. He had more experience in drug raids and everything than I do.
But he didn't mention his intention or his intent to do anything about it, did he?
No.
He didn't let you know of any plans he had to ensure the safety of the premises regarding Mr. Goss's suspected activities.
Objection, compound.
Mr. Mitchell did not express any intent to take these matters into his own hands, did he?
No.
This shooting occurred in the parking lot in front of your office, is that correct?
Yes.
your office is located outside of the security gates on your premises, right?
Yes,
In other words, the area where the shooting occurred is not protected by, security gates.
no,
So, so there was nothing preventing, any individual, much less Mr. Goss, from, entering this area.
no,
But you still think security gates are an effective measure to prevent, violent acts, on your property?
you know, we get the best that we can get.
Katie, you mentioned your preference for hiring police officers is as the best of the best, right?
Yes,
And you learn, you hear about available former officers from, friends of yours.
yes,
You know, you have relationships with, many police officers.
just different contacts, yes.
Throughout your hiring, did you do any research into what the training, into what type of training police officers undergo before they are hired on the force?
No,
So you have no personal knowledge of the type of training that officers receive before they put on their badge?
I trust the police officers in Harris County, so no.
So when you were hired, so throughout the hiring of former police officers, you never really knew what type of training you were receiving. Your security guards would have, did you?
No, I just assumed that they all received it from the police academy.
Right. But you don't know what it was,
No, I'm not a police officer,
but they were hired to protect property, right?
of course.
But you have no idea how they were gonna do that.
No, I didn't go.
They were not allowed to be armed, is that correct?
That's correct.
They had tasers and pepper spray, I believe, right?
Yes,
So they were going to go out there and protect the premises with their tasers and pepper spray and some sort of training?
yes.
No further questions.
Yes, Your Honor.
I'm gonna say, does the fact that Mr. Mitchell wasn't a current DEA agent erase the previous background and training he went through to become a DEA agent?
No, I mean, I believe once you're in the DEA, you're in the DEA.
And did you hire Mr. Mitchell?
Did I hire Mr. Mitchell? I did, yes.
And what were your expectations for Mr. Mitchell?
That he was, with his background, that he would investigate, or at least prompt me or investigate, possible drug activity that he believed needed to be investigated.
And when he came to you to talk to you about Mr. Morris Gus, did he have any proof?
No.
No further question. May the witness step down?
Recross? No recross.
Maybe. Defense, please call your next witness.
Your Honor, at this time, the defense calls Austin Allen.
Please raise your right hand. Do you swear or affirm that the testimony you are to give in this cause will be the truth, the whole truth, and nothing but the truth?
Yes.
Please have a seat. And follow your story.
It's kind of weird, I think. Sorry, it's kind of weird.
We can proceed.
Good afternoon. Can you please state your full name to the jury?
Good afternoon. My name is Austin Campbell.
Mr. Campbell, what is your current occupation?
I'm a premises and safety consultant, or excuse me, I'm security and premises safety consultant, and also a practicing attorney.
Can you please walk the jury through your education?
Sure, I graduated from Lamar University with my Bachelor in Criminal Science, magna cum laude. And then from there, I received my Juris Doctorate from the University of Houston Law Center.
Do you have any formal law enforcement training?
Yes, I completed the Houston Police Academy in 2008.
And can you walk the jury through your professional experience in security and law enforcement?
Sure. So I first worked for Swift Tech Security, first as a security guard and then as the manager of the company. From there, I joined the Houston Police Department there first as a patrol officer, and then as a member of the crime suppression unit for 2 years. Since 2014, I've been practicing law with a focus on personal injury. And then since 2018, I've been consulting on security and premises safety related litigation.
And can you explain to the jury what your work as a consultant involves?
So it's three things really. I analyze crime risks. I evaluate decisions made by property owners, and I determine whether property owners and managers in any given set of circumstances met industry standards with regards to premises safety.
Have you ever testified as an expert?
Yes, 37 times.
And what is your current involvement in this case?
I was asked to form an opinion on whether Spyglass Vista either knew or should have known of criminal activity on its premises, and whether in response to the alleged criminal activity, it acted reasonably based on the industry standards.
And what documents or materials did you review in order to form this opinion?
So I reviewed the deposition testimony and attached exhibits of Ms. Sylvia Scott, Officer Andrew Rubenstein, and Casey Hayden, the Spyglass Vista apartment manager. I reviewed the toxicology report, the employee report of Ryan Scott, the police report for this case, and Ms. Drew Simmons' expert report, as well as the original petition for this case.
Mr. Campbell, are these the type of materials that you usually review in order to form these type of expert opinions?
Yes, these are the types of materials I would request to review before forming any type of opinion on a matter such as this one.
And after reviewing this material, were you able to form an expert opinion on whether Spyglass knew or should have known of the dangerous condition in their premises?
I was, yes.
Please tell the jury your expert opinion.
So to a reasonable degree of professional certainty, based off of the materials I reviewed, Spyglass Vista had no reason to know of any potential foreseeable violent crime on its premises, and therefore did not fail in that regard, and therefore did not fail with regards to premises safety on its property.
Mr. Campbell, what is your understanding of the events that occurred on July 19, 2023?
So based on what I've read and what I've heard today, it sounds like Ryan Scott had been fired, I believe, earlier that day, that being July 19th, 2023, came back later that day on his own accord, encountered two individuals in a domestic dispute, intervened in that dispute, and was later shot.
And now, based on your law enforcement experience and training, was this death foreseeable?
It was not.
Why not?
So there have been no history of violent crimes on the property. I think, in this case specifically shootings, there was no gun-related violence, excuse me. There's no history of that on the property, so it couldn't have been foreseen. You can't foresee what hasn't happened.
And how does your background in crime suppression unit inform that opinion?
So in the crime suppression unit, we focus mainly on patterns of criminal activity. And again, there can't be a pattern of something that hasn't occurred.
Did you analyze any crime data regarding this area where Spyglass Vista sits?
Yes, I reviewed the same data that Ms. Simmons drew for her expert report, the 2022 violent crime statistics from the Harris County Constable's Office.
And what did you find?
So when I say that, I do want to add one key caveat. I focused on what I believe to be truly violent crimes, that being those against a person. Ms. Simmons' report included crimes against property, that being thefts and home break-ins where there was nobody home or nobody in the car. My analysis focused mainly on crimes that involved other people. But either way, no matter how you look at it, Spyglass Vista had the lowest number of crimes in 2022 for the other four apartment complexes in that area.
And why is that information so important in this case, Mr. Campbell?
So that, you mean, I'm sorry, could you explain that?
Why is that information that you found out so important in this case?
Yes.
Objection, leading, Your Honor. Overruled.
I'll repeat my question again, Mr. Campbell. Why is that information so significant to this case?
Well, it means that things that they were doing were working, and it means that they really had no reason to be on notice that in the area relative to their situation, there was any reason to foresee violent crime on the premises.
Did Spyglass Vista take steps in order to address this safety?
Yes, it did.
What steps did they take?
In 2020, I believe it hired 3 security guards.
And in your expert opinion, was this sufficient?
Yes, it was. And based off what I've reviewed and Ms. Hayes' testimony, the number of car thefts in 2022, I believe, was 0, which occurred after they hired 3 security guards.
Let's talk about Mr. Ryan Scott. What was his role prior to being terminated from Spyglass Vista in Spyglass Vista?
He had been hired and worked as a security guard for approximately 3 years before the shooting.
And based on your experience and training, what does this mean about his knowledge of the property?
So given his 3 years on the property, in addition to his police training, he would have been very familiar with the premises, the insides and outs, and what safety risks, if any, there were on the property.
Was Ryan Scott acting as a security guard during his shooting?
No, he wasn't. As I said earlier, I believe he was fired earlier that day, if not sometime before.
Did Mr. Scott involve himself in a dispute?
Yes, a dispute between Morris Goss and Alicia Gomez. And to my understanding, he used a derogatory term towards Mr. Goss.
And in your expert opinion, was the escalation to deadly force foreseeable?
No, and again, this is despite the fact that there was a derogatory term used in this case, and that's because, again, there have been no incidents of violent shooting, of gun-related shootings on the premises.
Mr. Campbell, did you evaluate any claims regarding Spyglass Vista having information of dangerous tenants?
Yes, during my review, I was made aware of suspicions regarding Morris Goss and Alicia Gomez and some classified them as suspicions. I classified them as speculation, really rumors about drug dealing going on in their apartment.
In your expert opinion, Mr. Campbell, did anything Spyglass Vista did cause the death of Mr. Ryan Scott?
Objection, Your Honor. This witness has not been properly designated as an expert in this matter.
May I respond, Your Honor?
Yes.
Your Honor, we are we're in the state court under the Texas Rules of Civil Procedure. We're not required to tender a witness status in federal court.
Oh.
I'm going to repeat my question, Mr. Campbell. Okay.
Please.
In your expert opinion, did anything Spyglass Vista did cause the death of Ryan Scott?
It did? No, they did nothing to cause the death of Ryan Scott.
In your expert opinion, Mr. Campbell, did anything Spyglass Vista fail to do cause the death of Ryan Scott?
Well, I would contend they didn't fail to do anything. So, no, nothing they failed to do contributed to the death of Ryan Scott.
In your expert opinion, what caused the death of Ryan Scott?
So this was the act of an independent outside actor, that being Morris Goss, who really had no connections to Spyglass Vista beyond living there, but there was nothing Spyglass Vista did to force Mr. Goss to shoot Ryan Scott that day.
No further questions. Thank you.
Cross-examination?
Yes, Your Honor. Mr. Campbell, you just testified that you looked at the Harris County Constable Office for crime data related to this incident, correct?
That's correct.
But you chose not to use the same Harris County Constable Office for their definition of violent crimes, correct?
If it's their definition, then that'd be correct. Yes, I took out violent crimes against purely property.
So you did not use Harris County Constable Office definition of violent crimes.
Yes, if that's their definition, that's right.
Instead, you chose your own definition.
Yes,
And earlier, you also testified that 3 security guards were sufficient for Spyglass Vista's apartments, correct?
that's correct.
Yet none of those 3 were on the premises on July 19th, 2023 during the day.
I believe Mr. Scott was the daytime security guard who had been fired earlier that day, so
So that's a no. There were no security officers on duty on the day that Mr. Ryan Scott passed away.
that's correct.
And so there's no security guard on the premises to protect Mr. Ryan Scott from the violence on Spyglass Vista's apartment complex.
Objection, speculation.
Overruled.
Could you ask again? I apologize.
There was no security guard on the premises to protect Ryan Scott the day of the incident, correct?
Well, yes, technically, yes.
And you're getting paid for your testimony today, right?
That's correct.
By defendants?
Yes.
No further questions, Your Honor.
No need to.
You may step down.
Thank you.
Defense, please try to answer.
We have no witnesses, Your Honor, to be breast referenced.
Are there any motions that need to be taken up to the
Not from plaintiffs.
All right, would y'all like a few minutes before we get into?
Yes.
Yeah, fine.
That's one of the better things. That one might be going now, though. This one, no.
Yes.
No.
Two rounds.
Yeah.
This is a shorter round. I know the spirit of the world is all that. Then it's almost an issue like. It was more of a shorter video. Oh, you're up to 23, 24.
I'm like, I don't stay over this in your mom is now good.
Lori. No, I my brother lost it. We want to do
Are you gonna use this? No. I'm just gonna.
Yeah.
We have an issue. What do we have an issue? No, I just wondered. I'm just thinking like. Just said, oh, never seen her. It's kind They should ask. No, I'm not. But I'm saying, it should be. Try that. I just don't want to be like in their face. I'm not gonna lead on it. Okay. I heard the beat. If you got it earlier. Oh, did you?
Governor, do you want us there, or do you want to just stand up and wait?
Oh.
You have 20 minutes, but you might, yeah, but you might go.
I'd be talking. No, can you give me like a 5-minute warning?
I'll give you a 10-minute warning, yes. I'll give you.
Oh, no, they will. It's not. It's good deal. We always get. Yeah. They have,
And then if I go like this.
DKNY.
Yeah. KNY, yeah. Yeah, you're more familiar with that than I am. You got tired of us in the first one. Oh, it goes around.
Yeah.
He's got a back away.
Oh.
Oh, you got a better pen. I did. I was like, no one tells you when you're younger that you become a pen snob as a young adult. What is it? So.
You may proceed.
Yeah.
Ladies and gentlemen of the jury, this afternoon, I don't even know. This afternoon, my co-counsel, Ms. Lee, stood up here and shared with you the foundations of our case. Those foundations being dangerous conditions, foreseeable violence, and a death that was preventable. And now you've met our witnesses, you've heard all of the facts, you have had an opportunity to judge them as you will, and it is time for you all to make your decision. Ms. Lee and I are here today to ask you to render a verdict in favor of Ms. Scott and the estate of her late husband. But to be clear, ladies and gentlemen, I think everybody here is in agreement that this is not just about legal wins and losses. This is about an
immeasurable tragedy and a life that was taken much, much too soon, and the beginning of the path forward for this family. Now, the tool that you guys have to render this verdict is what we call the jury charge. And I want to spend the next few minutes with you guys to run through that charge and piece together all the puzzle pieces and finish painting that picture for you while the information is heard here today. As the plaintiffs, as you've heard, our job is to prove to you by a preponderance of the evidence that the negligence of Spyglass Vista led to the death of Mr. Ryan Scott. Now, preponderance of the evidence, what that means is more likely than not. That does not mean 100% certainty. That means 51%, not 60, not 55, 51%. We're at the goal line. We just need to get you just to the 51-yard line, and we have done our jobs. And if we have done our jobs, then by law, the verdict, you are required to render the verdict in that favor. So let's go through this jury charge. Question number 1. Did the negligence, if any, of those named below approximately cause the death of Mr. Ryan Scott? Now, negligence, premises liability, we have some definitions for you here. And these definitions can be broken into four different principles. Start with, did the condition pose an unreasonable risk of harm? Let's talk about the risk of harm that we heard about. We have crime row, the neighborhood, a colloquial term that is used by law enforcement and people in the area, even tenants, to describe the neighborhood. It is true that it is not a crime to merely exist in a dangerous neighborhood. However, it is the duty of the buildings in that neighborhood to reasonably protect their tenants from these dangers. There is a security gate on Spyglass Vista premise. But there wasn't a security gate in the area where Mr. Ryan Scott was shot. There wasn't a security gate protecting Miss Casey Hayden's office from public access. There wasn't a security gate protecting the mailboxes. There wasn't a security gate protecting Mr. Ryan Scott when he came to visit the premises that day. Now, we can talk all day about what it means to protect a part of the premise, but what about the rest of the premise that still has access to the rest of crime? We heard a lot about security guards, including Mr. Scott himself. We learned about the guards and their addition to the security protocol after this 2019 drug bust. We learned about these guards were armed with tasers, they were armed with pepper spray, and they were armed with some sort of training. We don't know what kind of training you had. Yes, they were former police officers and DEA agents. But Miss Hayden, the individual at Spyglass Vista responsible for upholding the security standards, she couldn't tell you what kind of training they received. She couldn't tell you what kind of skills these security guards were made sure to have so that they were able to do the job that they were hired to do. Next, the next part of the definition here. Spyglass Vista Apartments knew or reasonably should have known of this danger. Again, crime row. The name in itself implies dangerous conditions and knowledge of that risk. Ms. Hayden was aware of the former DEA agents' suspicions of possible drug activity. Yes, they were suspicions. there was no action had been taken on him. But that's just the problem. No actions were taken based on the information of this former drug enforcement officer. Ms. Hayden told us that she expected this man to take matters into his own hands regarding this issue. But she couldn't tell you what those steps would have included. She wasn't a security guard. In her mind, it wasn't her job to do anything about it. But we also know that the security guards did not have policies in place to guide their standards of operation while they're on the job. So how are we supposed to feel safe knowing that Mr. Mitchell himself had no idea what he was supposed to do with this type of information, but he was supposed to take matters into his own hands? All of these actions led to a murder on this property. Yes, there was no history of gun violence at Spyglass Vista. We heard that from our witnesses today. But one murder is one murder too many. And it is not something to brag about having only one. Spyglass Vista failed to exercise ordinary care to protect Ryan Scott from the danger by both failing to adequately warn Ryan Scott of the condition and failing to make the condition reasonably safe. All right, let's talk about this. Ryan Scott was not on the job as a security guard at the time of his death. We know that. But we also know whether or not he was on the clock or not, we know that he was not aware of these suspicious activities involving Mr. Goss and Ms. Gomez. He was not provided the information that could have been made available to him, that could have had an impact on the decisions, the split-second decision he had to make when he saw this domestic violence occurring right in front of him. He saw a woman thrown to the ground, and he's a protector. He was a police officer. He's a security guard. He followed his protective instincts, and he stepped in to help. He had no idea what he was stepping into, did he? Yes, he saw this woman get thrown to the ground. He had no idea that if he would have the information regarding the suspicions of Mr. Goss should have been shared with this man who was responsible for protecting these premises. But they weren't, and he went in uninformed and he lost his life. Failing to make the condition reasonably safe. We've heard about the gates. We've heard about the cameras. We've heard about the guards. We've also heard about a murder in broad daylight on the parking lot that was left open to the public. This occurred in the middle of the day. Well, this occurred during the daytime. Where were the guards? We heard Mr. Campbell. He shared with us, he has no idea if there were guards on the premise when the shooting occurred. Who was protecting these individuals during the daytime? The answer is nobody. And so we're asking you for question 1 to answer yes for Spyglass Vista. And we've heard about Ryan Scott. We have heard about his character. We've heard about his relationship. We're not here to say, we are not here to say that he was perfect. He was fighting demons, just like the rest of us. But you've heard the facts, and now it's up to you to do with that information what you will. I can't tell you how to answer for Mr. Ryan Scott, but I can tell you how you should answer for Spyglass Vista, and that answer should be yes. All right, question number 2. We're going to leave that. All right, this brings us to question number 2. If you answer yes to question number 1, we're going to start talking about percentages. What percentage of negligence caused the occurrence do you find to be attributable to each of these individuals? We're asking that you put 100% for Spyglass Vista. And I want you to pay attention to one thing quickly here. We've heard about the shooter, Mr. Morris Goss. Where's his name? His name isn't on there. It could have been, but it isn't. But that doesn't matter for us here. Because what we have to work with here is Spyglass Vista and Ryan Scott. So we're here to ask you to answer 100% for Spyglass Vista. And 0% for Mr. Ryan Scott. Spyglass Vista was responsible for the safety of these premises. At the time of his death, Mr. Ryan Scott was not. Let's move on to question number 3. Question 3 and 4 talk about the damages. I want to get into damages briefly with you. Question number 3 is related to Mr. Ryan Scott. And it's kind of a unique thing that the law allows you to compensate a deceased individual for the pain and suffering that they experienced before their death. But it does. And that's what this question is asking you. Mr. Scott was shot 3 times. He lied on the ground for minutes before he passed away. He lied on the ground for minutes, choking on his own blood, fighting to breathe, fighting for his life, lying there alone, thinking about his wife, thinking about his family, thinking about these individuals who he will never see again. We can only imagine how long those minutes must have felt. 3 shots. So we are asking you to award $3 million in damages for the 3 shots fired into the body of Mr. Ryan Scott. And the parties have stipulated that the total amount of funeral expenses is $24,700. Last question. What sum of money, if any, would fairly and reasonably compensate Mrs. Sylvia Scott for her damages? Mr. Scott and Ms. Scott were married for 15 years. They dated in high school, they got married. She's 33 now and a widow. They met before they were 18. They grew up together. They are all each other knows. Everybody knows the amount of growth that occurs between high school and 33 years old. That's immeasurable. There is no amount of money that can compensate for the loss suffered here, but we are going to ask you to compensate, to award Ms. Scott $15 million in damages for the 15 years that she experienced with her husband. We are going to ask you to award. We're going to ask you to award $5 million for the future. For the future damages that for the future loss of companionship that Ms. Scott will undoubtedly experience because of this loss. 5 decades that they're going to miss together. They lived till 80, which, one can only hope. That's 5 decades that she now has to plan without her husband. Ms. Scott had to go down and identify her deceased husband's body at the police station. We heard that in the deposition testimony. They were supposed to have Italian food that night. They were supposed to have a date night. They were working on rekindling their marriage. We can only imagine the sadness that comes with knowing there will be no more shared meals. There will be no more building that relationship. And so we're asking you for $1 million each for the mental anguish suffered in the past and the future for Miss Sylvia Scott. Ladies and gentlemen, this family has been ripped apart But it didn't have to happen. Spyglass Vista could have done something to prevent this. But they didn't, and now we're here asking you to provide a glimmer of hope to Mrs. Scott and her family so that that way they can build their path forward. Thank you.
Yes.
Thank you, Ryan. Earlier today, my co-counsel came up before you all opened statements and told you that this case was about where responsibility began and where it ended. See, Spyglass Vista, they hired security guards to keep their apartment complex safe. They installed cameras and they even ran background checks on every single tenant that signed a lease there. But one afternoon, man, he made a choice. See, members of the jury, the law recognizes that we are each responsible for our own decisions. But what the plaintiff is asking you all to do here today is to ignore the man who pulled the trigger and instead reach into the pockets of Spyglass Vista, the apartment complex who did implement measures to protect the very violence we're talking about here today. They're asking you to blame the shield for the damage done by the sword. See, we learned today that Spyglass Vista took some steps. In fact, plaintiff's own witnesses testified that some steps were taken. When there was a drug bust in 2019, we learned that management didn't just look the other way. No, they hired additional security guards to patrol the grounds, and one of them being Mr. Scott himself. And we learned that Mr. Scott was a former police officer. See, he knew of the risks. He knew what that neighborhood was like better than anyone. But on July 19, 2023, Mr. Scott was no longer an employee for Spyglass Vista. We learned he had been fired for being drunk on the job and harassing the very tenants he was paid to protect. We learned that he came back to the apartment complex, and we learned that he saw a dispute between Mr. Gus, the shooter in this case, and Alicia Gomez, Mr. Gus's girlfriend. And we learned that there was some type of altercation going on between them. And the evidence showed you all today, members of the jury, that Mr. Scott interceded this encounter. And he didn't just intercede. We learned that aside from him trying to save this woman, he provoked a man by calling him a derogatory term. See, Spyglass Vista cannot be the one to blame when they hired former police officers, and those former police officers ignore their training and provokes a killer. Now, the plaintiff came up here before you all today, and they want you to believe that Spyglass Vista knew of the risks, that we knew that Mr. Gus was a dangerous man. But what is their evidence? They point to a suspicion from Mr. Mitchell, who stated he had suspicions of drug activity, but he had no proof. They want to punish the landlord for not evicting a tenant based on a hunch. And they point to the statistics in the area, the apartment complex, but they conveniently ignore that Spyglass Vista had the lowest crime rate out of all of the other 4 complexes. The plaintiff's case is asking you to predict a murder that even a former DEA agent couldn't predict himself. Now, before we go through this jury charge, members of the jury, I'd like to talk to you about who bears the burden of proof in this case. And that's the plaintiff, Ms. Sylvia Scott. She bears the burden of proof in this case, and she has to prove her own case. See, the defendants, we don't have to prove anything. And we certainly don't have to prove that Spyglass Vista was perfect. Now, here's what makes the plaintiff's burden so important. The plaintiff doesn't just get to meet one element and coast through the rest. No, she has to meet every single element on this jury charge. You can think of it as 4 locked doors. Ms. Scott needs a unique key to get through each of those doors. And if she doesn't have a unique key to get through one of these elements, well, members of the jury, she can't recover. So let's look at these elements and explain to you why she doesn't have the keys. Now, the first element, did the condition pose an unreasonable risk of harm? We learned that the evidence showed that Mr. Gus coming up to that property and shooting Mr. Scott was a random act of third-party violence. That was an unreasonable risk inherent to the premises. That was a new and independent cause, and it broke off any chain. It broke off the chain of causation for Spyglass Vista. Mr. Campbell, he got on that stand today and made that pretty clear, that this was a random act of violence. Now, when we look at element 2, Spyglass Vista Apartments knew or reasonably should have known of the danger. Spyglass Vista didn't have any information, members of the jury. They ran a background check on Mr. Morris Gus before he rented a lease there. And this background check, it checked his criminal history, his credit, tenant report, identity verification, criminal record. Members of the jury, nothing came up. And the prior domestic violence call we learned today resulted in no charges. Nobody was injured. In fact, Ms. Gomez took away and removed her charges. And the police didn't find it significant enough to arrest the man. So why should the property manager from Spyglass Vista feel like he have to do something about it? Now, when we look at the third element, Spyglass Vista Apartments failed to exercise ordinary care to protect Ryan Scott from the danger by both failing to adequately warn Ryan Scott of the condition and failing to make the condition reasonably safe. Well, members of the jury, we've already proven to you all that Spyglass Vista did exercise ordinary care. They hired security guards. They installed security cameras. They had access control gates, and they ran background checks on every single tenant, members of the jury. Casey Hayden is, we learned from Casey Hayden's testimony that the whole reason why she hired these security guards was because she expected these security guards to come with the background training from being in the police department. Ms. Hayden isn't a police officer. Of course, she doesn't know what training goes into it. All she knows is that these security guards were former police officers who already had a good understanding and a background to be able to do the job that was assigned to them. Now, we learned about the fact that Mr. Scott had called Mr. Gus a derogatory term. See, Spyglass Vista, they provided a reasonable, safe environment for Mr. Scott, but they couldn't make a situation safe when a former employee, a former security guard, a former police officer comes up and provokes a killer. Now, when we look at this jury charge, members of the jury, we have 2 options here: Spyglass Vista and Ryan Scott. Spyglass Vista is not responsible, members of the jury. It was Morris Gus who pulled the trigger. It was Morris Gus who decided not to shoot Mr. Scott, not once, not twice, but 3 times. We even heard testimony from plaintiff's own witness who admitted that the reason why Mr. Scott isn't here is because Morris Gus pulled out that gun and shot him. And so for that reason, members of the jury, we're going to put a note for Spyglass Vista. But Ryan Scott's still on there. Members of the jury, we really didn't hear much about Mr. Scott's negligence or how Mr. Scott caused his own death. There was no testimony that Mr. Scott took a gun and shot himself. We didn't hear that. And we might have heard that Mr. Scott, and while we did present evidence that Mr. Scott had some drinking complaints while he was on the job, we don't feel that that led to his death. Because what led to his death was Morris Gus. And so for that reason, we're gonna put no. Now, members of the jury, no one here is bragging about the fact that there was only one murder that took place on this complex. Nobody in this courtroom is going to stand up here and tell you what happened to Mr. Scott wasn't a tragedy. It was. A man lost his life. A wife lost her husband. That is sad and that is devastating. But your job today is not to ease the pain by writing a check. Your job is to follow the law and go where the evidence leads. And the evidence leads you to only one person and one person only. And that's Mr. Gus. Spyglass Vista was the shield, and Mr. Gus was the sword. You simply cannot punish the shield for the damage done by the sword, because the responsibility began with Mr. Gus, and it should end with Mr. Gus. On behalf of Spyglass Vista Apartments, members of the jury, we ask that you find the only verdict possible and hold us not liable. Thank you.
Rebuttal? Briefly on it.
We heard from opposing counsel a lot about Mr. Morris Goss and his, and how this accident was entirely his fault. And of course, he has a large role in this. I mean, he pulled the trigger. He chose to commit this act of violence. He took the life ultimately. But where's his name on the jury charge? Spyglass Vista really thought he was at fault completely for this accident. Why didn't they add him to this case? Why didn't they add him on the jury charge? We don't know, but they didn't. Maybe it's because they're grappling for a way out from under this this liability. We don't know. All we can say is that Mr. Morris Goss isn't here today, but Spyglass Vista is.
Yes, it's, you get 3 hours for, oh, you already got, were you here before? No. Oh, you said also it's on. He judges all. Oh, got it. That's too bad. Not as
I was
first person.
pleasantly surprised yesterday, so even though I don't get credit for both of them, like, oh, well.
You already got one.
I have one. One's better than nothing.
Well, no, I thought you were saying earlier, Judge, that
Yeah, you
you
can
get
just be bad.
3 per year. I thought it was
Can I
3
just
hours.
take, oh.
Like, you get 3 hours of self-study. Like,
Yeah,
the
yeah,
motion
yeah.
is 3
No,
hours
she said it
for
doesn't even
judging.
count towards self-study.
It doesn't count towards self-study. This is separate. It's a
Yeah.
new legislation was passed.
Oh,
So you can get this in addition to the, and so what you do is you'll just email it, scan it and email it in.
You just scan things.
no, you take a picture. I thought I knew what the last one, I take a picture of my
You know, I
phone.
do, I give it to my paralegal. She
Well-
scans it for me.
Same difference. Somebody else will do it.
I was gonna say, everyone give it to me, I'll hand it to my.
Yeah, our scanner, half the time it works and half the time it doesn't, and it requires all these steps.
I know you
But my
need it.
paralegal has one on her desk, and I'm like,
No, I already text that.
And I can never figure out,
Break,
every time I figure out how to scan, you change the rule,
yeah.
or like the Rico machine changes on how to scan things.
I didn't even know what, they were
We have to
seeing
put a code,
project.
Yeah.
and another code, and another code, and then go through this like
I know nothing
whole
about it.
series.
And you
of
gotta
button
find where it
pushes.
goes on the computers.
Yeah. Ryan Gosling's was be very good.
Oh, that's my wife.
It's like,
Okay.
Yeah. Because if you don't have one.
So I've done all the talking today, and then I'll let
I would
jury
say- I would
give you
be-
trust that, because you are gonna get, as a problem, the best feedback you can get from jury, and not just. What's up?
Yeah, when we start. All right, I'll start since I'm.
You go.
Okay, we'll go this way then. I just have some general stuff.
Tell them who you are.
Oh, I'm Shane Osborne. I'm a partner at Martin DeSeer, and I'm a trial attorney. I know it's hard because you guys just found out you were in the finals, but on depot reads, just when you're actually doing it in trial, have one person do it and coordinate with the other side, right? Where you're not repeating the same thing. You know, I only remember hearing a couple of lines, but jurors' time's precious, and if they hear the same thing over and over again, it seems like you're wasting it. So that was just, go to my notes. This is a personal preference of mine. I'm not saying you guys have to abide by it at all, but whenever I'm questioning a witness, I don't ever look at the jury. I want them to focus on the witness, don't focus on the person asking the questions. And a lot of y'all, whenever you were asking a question, then you look at the jury, right? Like right after you ask, like, are you guys paying attention? I just personally don't do that. I want them to focus on the testimony being made, take it with a grain of salt, take it or leave it. That's just me personally. When you hear a judge say that objection is overruled, all right, that means start racking there's another one, right? I've even had some judges say, well, that objection is overruled. Do you have another one? Which I'm sitting there going, are you kidding me? Come on. But just anytime a judge says that objection is overruled, just make a mental note of, okay, what else can I object to? Because that normally means there's something else you could do that you hadn't done. We were talking about this briefly. Don't waste time on frivolous motions of limine, right? Like, okay, we don't want him calling him a drug dealer, but they could say he was dealing drugs, right? I mean, you kept a straight face for the most part, but no.
Straight face, I would've said that.
Okay, so I mean, just again, fight your battles. Plaintiffs count. So I'm a defense attorney. I do represent plaintiffs, just not in certain aspects. But you guys called it an accident. Every defense counsel will shove it down your throat anytime you use the word accident. All right, so this could be a tragedy, a tragic loss, a horrific event, or even better, a preventable murder. Right, but don't ever call it an accident, because then then defense counsel say they call it an accident themselves. So just keep that in mind. Whether or not the judge has a copy of exhibits, I don't know if y'all both did it or not. Do not ever ask a judge if they want a copy of an exhibit. If they say no, that tells the jury, well, if the judge doesn't care about it, I don't care about it. So if the judge wants a copy, they'll ask for a copy. Or they normally have a binder up there of all the exhibits, even the ones that are admitted or not. But if you ever ask a judge in front of the jury, hey, would you like a copy? The judge goes, no, I'm good. That just signals to everybody else, it's not that important for the judge to even need a copy. What do we care? The last thing I have is nobody moved for a directed verdict on the plan. Y'all didn't move for a directed verdict on Scott's negligence. I don't know if y'all were supposed to, or if y'all weren't allowed to. I didn't hear any testimony that, that he did anything wrong. He might have been drunk. He might not have been. There was no toxicology report discussed, nothing like that. And then also for defendants, you guys did not move for directed verdict on any of the non-economic damages pursuant to Shohan. Now, obviously, everything would have been denied, but that's one of the things that I was at least expecting to y'all move for a directed verdict on the negligence of Scott, because I didn't think there was sufficient evidence of that. But look, great job, guys. I know it's Sunday afternoon. Y'all have done this I don't know how many times, but really good job to both sides. So.
I'm Jessica Platt. I'm a partner at Lonza Law Firm, and I also do defense. And so I agree with everything Shane said. Also, y'all agreed to admit the expert report, which y'all didn't catch is on the very first page of their expert report.
Oh, yeah.
It said known drug dealer. Y'all fought so hard about that. And the very first page, it says known drug dealer on their report. Anything that's going to be seen by the jury, you better have gone over that with a fine-tooth comb to make sure that it complies with whatever rulings have been made or agreements y'all have come to before. Because that's a mistake that I don't know if it would have changed the outcome of this, but you fought so hard to keep drug dealer out. And then that's the very first thing it says is known drug dealer, not just suspected or anything like that. So make sure whatever is going back, you have looked at very carefully. And then this is more of a in most motions in limine, you got away with a lot in your closing. Yes. Yeah, Sartain, I don't remember your first name, sorry.
Katherine.
Yes, Katherine. I wrote everyone's last names down and not first names. Most motions in limine will not allow you to discuss why someone is or is not on the jury charge or other rulings of the court, which y'all missed as well. You could have objected there and you didn't. And so that gave her the opportunity to sit there and say, he's not here, could have done it, and they didn't. So, I mean, if the jury hears that and then thinks, oh, well, yeah, they could have put him on there. She said they could have put him on there and he didn't. So what's wrong here? And then a big thing for me is I always will anchor. I will always give numbers at the end. I would say, I don't think that we're responsible for this, so you put a no. However, if you do so, then let's go on to question 2. I think this is 100%, or, we don't have any, and we certainly don't go above 50% or 51%. However, if you do, because if you don't give numbers, all the jury knows is the 26 or whatever million that plaintiff has said. And so they don't know if that's unreasonable or not. They don't know if that's a good number or a bad number. Whereas if you had said, all right, if you think so, then they talked about her problems in the marriage and things like that. And so you could have said, all right, so in the past, give her $10,000 or just something so that the jury has a number to think about. Otherwise, they're going to do whatever they want, or they might give them all the money. So, but yeah, no, y'all did a great job. And I was pleasantly surprised with everybody. So good job.
My name is Marianne Roback. I'm a litigation partner at Shackelford, and I do not do personal injury or plaintiff's work. I do business disputes. So I don't even know what she's talking about with Anchor because I don't deal with it.
Everybody's wondering, who invited her to come?
But I do know a lot about rules of evidence and the proper way to handle evidentiary issues in trial. So I'm going to focus on that rather than, the personal injury aspect of it. You guys need to always go back to your old friend from your first year of law school, Iraq. When you have an objection or a motion in limine, you always frame it just like you did Iraq. What's the issue? The expert report is hearsay, which none of y'all objected to, but that's the issue. The rule of hearsay is it's an out-of-court statement offered for the truth of the matter asserted. Analysis. Then you go into, these are all opinions, it's all speculation. It's based on other hearsay documents or other hearsay statements. Therefore, conclusion, it should be excluded. Every single objection, right? But here's the other thing. When you say the issue, that's motion in limine, that's how you frame all your motions in limine or motions to exclude, whatever motion it is. But in trial, if you object to hearsay, you just stick with objection, hearsay. Stop. The judge will then look to the other side because sometimes the judge will go, stink. But sometimes then if the judge is unsure or wants a response, then let them try to figure out why you're saying hearsay. Then they're like, oh shit, is it? Sorry. Oh shoot, is it? Okay, what's the rule? Blah, blah, blah. Then they're stammering to figure it out. But if you say, just like thou doth protest too much, hearsay because this is a blah, 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 blah. First of all, you're wasting every time because everyone in the courtroom knows what the hearsay rule is. So we don't need to be regurgitating that. And then you might get the judge to go with you, boom, like that. And then you're also like coaching them on what you think the problem is so that they now have the 30 seconds or whatever to prep. So objection, hearsay, objection, leading, objection, pulse for speculation, and then stop. But then have your rack ready to go, right? Have your analysis, have your conclusion and everything ready to go once their side explains why it's not hearsay, that you can explain why it is. And also for a lot of this stuff, it's hearsay, but it's also hearsay within hearsay. There's 2 layers. And that's what the problem is with this report is because yes, it's her opinion, but she's here. She can testify to her opinion. You don't need this. This comes in and it goes back to the jury now, and the jury can read it and highlight drug dealer and highlight. I've got other points in here. You don't want that because she's never going to get to say this guy's a known drug addict on the stand. Like that never is going to get in, but you just got it in here with this report. In state court, expert reports never come in unless you're using it for impeachment. And when you use an expert report for impeachment, it doesn't go back to the jury. I mean, it just doesn't get in. So, so be mindful of that, that just because it's an expert and just because they wrote this doesn't mean this automatically gets in. In the opening statement, plaintiff's open, you were extremely vague as to what the evidence was going to show. You didn't say, you're going to hear from this witness who's going to tell you that they hired security guards. You said, you're going to hear from this witness, and I want you to listen to what they say about what they did or who they hired. Tell them what they're going to hear, right? It's the rule of threes. Tell them what they're going to hear, then they hear it, then at close, you told them what they heard. So just be very frank. You can say, we anticipate the evidence will show, we anticipate they'll testify this, but put it out there. And then in plaintiff's open, you said that Mr. Scott was in an impossible situation. And I didn't really like that because really he wasn't. He could have just chosen not to get involved, right? And then the questioning of Rubenstein, and again on this side, the questions were very long. Like you don't need to, like I think I actually wrote down one of them, but anyways, just really wrong when you could have just said why. Now you say that they did this and da da da. Why do you think that is? When you could have just said why, and then let the witness be the star of the show. And then the Mr. Ryan Scott, it's either Mr. Scott or it's Ryan Scott, but Mr. Ryan Scott, I think that was y'all on y'all's side. That was just a lot of words.
Just one more thing while I'm thinking of that. Don't ever call them the defendant. Don't ever call your client the defendant. Call them the apartment, apartment complex. Don't ever, you call them by Mr. and Mrs. Do not ever call your client the defendant. And if you, in a lot of times, here it's a fatality, it's a death case, don't ever call, but the deceased, but also plaintiff, try to not refer to them as a person, where it disingenuizes that they're a real person by referring to somebody as a plaintiff. Don't ever refer to your own client as a defendant.
Yes. And the wedding photo, that's just a really key example. And again, I'm just going to focus on trials in general. Only pre-admit exhibits that you absolutely 100% know you're going to use in court and you're going to want the jury to have with them when they go back. Because y'all, we get exhibit lists that have 200 exhibits on it, or even 50 exhibits on it. And only maybe 10 of them get in, or if 20 get in, then guess what? The jury has to look through all of them. You wonder why juries sometimes deliberate for like a day. It's because there's too many extra exhibits that don't move the ball forward, but they've been pre-admitted, they're in. So now they got to look at them, especially like depositions or big old things like, so the wedding photo, I think y'all didn't use it properly. I think it should have been blasted across anytime you got the opportunity to. You should have had her talk about her wedding day. You should have had all this, but you didn't. And then in closing, you just had it up there and you didn't even talk about the wedding picture. And of course, that's just one page, so it doesn't really matter in the grand scheme. But for your future, when you have an exhibit list, try to pare it down to what the jury is actually going to need to get to the end of the road. Because otherwise, there's just a lot of documents back there that they don't know what it's about. They don't know why it was there. And they're going to spend 15 minutes or even more going, hey, do you guys know why this was in? What did they talk about? When did they talk? Do your notes say when they talked about this? You don't need that. Just get to the end of the road. And then know the difference between refreshing a witness's recollection versus admitting an exhibit into evidence. Refreshing recollection is if they say they forget or they don't remember that, would something aid you in refreshing your recollection? Yes. Would this document aid you? Yes. May I approach? Yes. Have them read the document and let me know when you're finished reading it. I'm finished reading it. Does that refresh your recollection? Yes. Okay. What was the date of the murder? Right? You don't have them look at it and keep it up there and talk about it while it's up there. And y'all didn't object to that it was just up there. I don't even know what it was. And then I think you tried to publish it to the jury. And so you don't publish refreshing recollection or impeachment materials to the jury. You only do that after it's admitted into evidence. And it might have been, I don't know what the document was, but Then the whole time I kept, and you got to it at the very end, but it should have been brought through the whole time, that it doesn't really matter how many guards they hired. It doesn't matter how many background checks they did. It doesn't matter if they had a DEA person working there. None of that matters because there was not a guard on site at 4:47 p.m. when this guy was murdered. So all the due diligence they did in the world doesn't matter because there was no guard there. And there was no questioning of your experts as to should there have been a guard there during the daytime? Because the testimony was they only had a guard at night. So none of the other stuff mattered. But you did get to it in your cross at the very end, and it was great. Great how you did it, but it should have been weaved through the whole time. And that's it.
So they have been very helpful in detail about their feedback. My name is Alice Lovchik. I'm a plaintiff's attorney. I represent injured people. I help people. Yes.
Elevator pitch, everybody.
I have the privilege to have worked in the defense like these people here. So I have a brain for defense and plaintiff at the same time. So they help me a lot. I realize that both of you all do defense work. You don't do plaintiff work. So I'm going to skip my tips for the plaintiff work because I don't want you to know that.
They might do plaintiff's work one day.
But for the defense work, you're representing a corporation. I was fortunate to work under the associate for a defense attorney that was one of the finest defense attorney. He passed away. His name was Daryl Barger. And he was amazing in humanizing corporation. Okay. And you all did a great job explaining the evidence and opening, and throughout the case, you need to find a way to humanize your client. Okay. Because at the end of the day, the jurors are going to be sympathetic. It's natural, human nature to the injured person. Okay. And at the end of the day, you want the jurors, when you're defending someone or a corporation, you want them to realize that behind that corporation, that deep pocket, there are human beings that are running the corporation that care about the services, that care about their tenants and all of that. So I think you all need to do a better job on humanizing your client for the jury, so that you can find a way to connect your client to the jury. Okay. You did a very good job in your opening about humanizing the client, but that's what I do. I would go more in details. It's like, who was this person before? And what happened? And what was lost by my client? You know? So that's what jurors want to know. It's not the one event thing. It's like the, things, daily, in the daily, day-to-day that was missed by the widow, with the loss of her partner, her life partner. Okay. The other thing that I recommend to both of your teams is being intentional. Everything that you ask to a witness has to have a purpose. Take away all filler questions. Just keep only the questions that have a purpose to build your case. Okay. Jurors get bored. Jurors take naps. I'm telling you the truth.
Yeah.
They take naps whenever they are not entertained. So be very intentional when you're crafting your direct examination and your cross. Be intentional. What is the purpose of that question? Is that true? Is that really relevant to ask that? Is it going to prove my point? Or is that just a filler question? Just take out your filler question. In reality, when you're working on your outlines, you should have one ready and then go over a day later, not a day before trial, a day later, and just take out the filler questions, the questions that have no purpose or no, to save time. And then finally, this is when you're closing. I want to talk about closing a little bit. if you don't believe your client and on your ask, the jury is going to know. Okay, so when you're delivering, you must believe. Otherwise, they're gonna smell it and gonna turn on you. Okay, so you have to, when you're defending, I understood everything that you explained, but I didn't get that you were believing what you're saying. You know, so when you deliver, you must believe. You know, and they find ways to believe, review the evidence. And I do that for the plaintiff, and you're not gonna represent plaintiffs, but for you, I didn't find that you were believing on those numbers that you were saying there. Yes.
Okay, sorry.
Yeah. I didn't find that you were believing on that. And I didn't feel like that was really intentional and, you know, it wasn't supported by the evidence. All of you do the defense. You could have got very good issues for appeal on Gregory versus Chorhan, because those numbers were not anchored anywhere in the evidence. And also in the new Exxon case that came out recently on the Court of Appeals. So at the end of the day, my final recommendation is like, know your facts inside out of the case, know your records, know your facts, read the reports before they go. Any exhibit that you intend to offer to evidence, you need to know with your eyes closed what is in there. And you need to know what you're going to object. And you can't, like, I never agree to experts report coming in because they're hearsay. And I'm always scared that the jury is going to have something there that I lost, you know, that I didn't see, that I didn't catch. So I always object to that. And then also, that's pretty much it. You know, be yourself, but be intentional, and you need to believe your case. If you don't believe your case, you should not be representing the person. You know, that's the main takeaway.
Can I add one real thing? I just remembered. Demonstrative aids are super great, but only if a jury can read them.
Oh, yeah.
So those are
I don't
too
know if you saw, I
tiny.
was going like this.
Anytime you use a demonstrative, blow it up and then put it like on the other side of the conference room in your office and see if you can see it. Because if I can't read it, it's absolutely pointless.
And we're in the front row too.
The text or the handwriting?
All
The
of
text,
it.
we can see your
The
handwriting.
handwriting was great, but.
Yeah.
Oh, it needs to be
Text.
huge. If you're gonna use it, make it jumbo.
That font needs to be a lot bigger.
Yeah, yeah. We borrow those from another team, but.
Yeah. But it's just practical for future.
Agreed, yes, no, thank you. Yeah.
Now, but with that caveat though, if it is the charge, everyone's gonna have one in front of them.
Right.
So if you can't see it, you can read along. It's just one of those deals. But yes, I agree.
And I use the Elmo for my charge.
So do I.
And
I
write on
would,
it.
to be fair, I would not let any of them use technology because we're in so many different courtrooms that
okay.
technology is the same in every courtroom. I think it's fair.
Well, in
I
real
don't
court,
ever use technology. I use phone boards still in the year of our Lord 2026 because technology always breaks.
Yeah, I had to buy it. We were in one of the new courtrooms. Well, the old one didn't work. And one of the new courtrooms that had the new technology literally broke the day I want to travel.
I just don't do it.
Maybe you broke it, Shane.
I probably did. I don't know. But yes.
Cristen Lee, board certified family lawyer and former district court judge of a family court. So a little bit different wheelhouse in the sense that kind of like the stepchild of the civil court, where we're in the civil court, but functions somewhat differently. But there's a lot of, pretty much when I was presiding in any hearing I have, it's all evidentiary. Because you're either arguing about property and values and how you're proving up the values, or you're arguing about best interest, material change in circumstances for a kid. So everything is evidence, you know, lots of hearsay stuff. So for the reports, you know, on its face, it's hearsay, but when the other side doesn't stipulate, is it a summary of voluminous information and documents? Would it be of aid to the jury or the finder of fact in analyzing the issues and coming to a conclusion? So there are ways to get it in. You know, ask your witness who prepared it. You know, if I was to go through this report with you and ask you each item that you prepared and written about on this report, would your answers be contained within this report? If we did that exercise on the stand right now, would that take an incredibly long amount of time? Hearsay, if it is the basis of hearsay within the report, if it is being referenced as part of the expert's analysis is admissible. Rank hearsay, so like if there are exhibits that are attached where at the end where it's just somebody's statements or a questionnaire that they provided to the expert, object to that. I mean, because it's not part of the synthesis of what their opinion is. But if it's actually hearsay where it's being referenced in their professional opinion, they are allowed to talk about that. Like, well, so-and-so, it was clear to me that so-and-so was suffering because of the fact that he was goggling and he was gurgling and was struggling to breathe based on the reports or this person who described what they heard. So that if it's part of the analysis, it comes up. And this is going to kind of be all over the place because I was taking these as we were going. So there's not like an organization to this. You have to be careful about what you bring and where you stand, all that stuff. So for instance, I was kind of laughing, Katherine, that you have a water bottle that says American Outlaws. And I'm kind of chuckling to myself about the fact that you have a big sticker on your water bottle that says American Outlaws while you're trying to fight against the company because some guy got shot.
Oh, one other thing I forgot to mention. Thank you for bringing it up. Did you go to A&L?
Handout?
No, did you go to Texas A&L?
Oh, no, Texas Tech.
Oh, okay. See, I saw your gold ring. Most people who go to one of the things I went to South Texas, they always taught us is don't wear anything like your cross. Okay, you might have somebody who's Jewish, Muslim, a different religion on the jury. Most people, when they see a gold ring, they think of Texas A&M. They always said, do not wear anything that can identify where you went to undergrad, because for all you know, somebody on the jury could have gone to Texas Tech and they think, oh, you're an Aggie. You immediately start off on the wrong foot. Again, you're wearing a little cross necklace. Somebody might be offended because I'm just saying. One of the things they taught us was don't ever do that. So if you can, just try not to wear anything that identifies either religious or just anything that could be a negative towards you, because somebody doesn't even know you, but oh, I think you're an Aggie. I went to Texas Tech, or I went to UT. I hate Aggies. So right off the bat, you're starting off with the wrong foot.
And
So
juries see everything and the smallest, stupidest little things.
Yeah.
They will see it.
So the other kind of comment that I had that was kind of about just like the little stuff, like Cristen, when you came over here, you put your podium right here.
Yeah.
And like I could see your papers, like kind of, it was hard to read, but I could like see, kind of what you had on there and everything. And this goes back to the earlier comment where you want the witness to be the focus. And if it's your witness, so if it's your witness, you're trying to tell the story through your witness and you're trying to get them to tell the jury. If it's an adverse witness and you think that they're hurting you, which is the only reason why you actually cross-examine them, then you can make yourself the focus and you're just getting them to agree or disagree with you. And Enrique, I think you at one point asked a question, if I'm remembering correctly, on your cross where you didn't know what the answer was going to be. And it was like, oh, it was the policeman or something. And it was like a harmful answer. And then you just was like, no more questions. So instead of asking an open-ended cross like that, you could have said, well, when you prepared your, not the police officer, it was probably the report. Like when you prepared your report, like one of the things you didn't analyze in your report was, what could have specifically been done to prevent this crime, right? Well, yeah, that's correct. Rather than, was this preventable? For evidentiary objections, there was a lot of missed opportunities for narration, answering outside the scope of the question. There was also there's some hearsay. Exhibit 2 is entirely hearsay because these are just report like things other people said, so that could have been kept out. More broadly,
yes, because they'll never try this case again.
No, I know. So more broadly, you have to work backward from the charge, and you're doing that even if you're not doing a jury trial. If you're trying something to the bench, you figure out what are the elements that create liability or get you what you're asking for, and then you build your whole case and presentation backward from the questions or the elements that need to be established or answered in your favor. And you structure the entire case towards answering those questions. And as you're asking witnesses in your opening, then as you're asking the witnesses, as you're cross-examining witnesses, and as you're doing your close, you're signposting through that whole time, and then you're wrapping it up in the closing argument that you remember this person and how they answered this. Mr. or Mrs. So-and-so, I'm gonna ask you about, I'm gonna ask you about the company's negligence now. So you build backward and you use those questions to build out your theme. And some of the themes weren't super strong. So for instance, like a blind eye to crime. I mean, that's kind of like you could argue that's like societal. Like the whole neighborhood was bad, and is the focus on the fact that the neighborhood was bad versus the specific property. What about, like, in your opening, the evidence will show that they were aware their property was unsafe and they did not remedy those issues. They did not take adequate preventative measures to fix the fact that they knew it was unsafe. When you're doing the depo reading, read it yourself, because you don't turn that over to someone else and where you don't have control over how they put emphasis on things. Attorneys aren't allowed to testify in a case, and you're reading a depo, you kind of are. So when you're reading the depo and you're doing it in the narrative, question, blah, 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 answer, and then you can actually put the emphasis when you're delivering it, reading it into the record as you think it should be for your case.
Yeah, but
That might be slightly-
that
yeah.
could backfire. That could be easily backfire.
Well,
If you're
and-
putting-
Well, I mean, I'll have an associate come and
Yeah,
read it, and so
always.
I know,
Right.
they know what I want them to.
And I'm not
emphasize
saying
on.
be overly dramatic about it, you shouldn't be like clutching your chest,
Oh, this is-
stumbling around,
Right.
kind of thing. But you don't hand it to somebody, you either do it yourself, or yes, you have like a staff member do it, where or co-counsel, whatever, where you kind of know what kind of emphasis they're gonna give to what the jury's hearing, because you want the jury to be like, you want the delivery to focus the jury on what you want them to pay attention to.
I'll just text the WhatsApp. It was at 5:30.
One question I had is, why weren't either of the clients sitting at council table?
Well, one was at a funeral.
Well, I know one's dead, but what about like the spouse or? the
No,
corporate
she was at a
representative?
funeral.
She was at a funeral.
It's like a stipulated fact of the case.
Okay, yeah, that's right.
And we
What
couldn't
about,
mention that she wasn't here because it would be
what about the corporate representative?
Yeah, I guess you could have said.
Like you could have had the office admin or something been there as a corporate
No, she's
representative.
here.
Yeah, but she was
She's
back
there,
there,
she's
not
back
at the table.
The point being, like, and you don't keep saying, or at least in my preference, I wouldn't
Well,
keep
yeah,
saying the company's name. I'd be like my client. My client, sitting right here, my client.
I'm the opposite. I would say my client's name,
If it's a person,
even if it's a corporation, I would say the name, but it's just me.
it's
fine.
a preference.
Yeah, it's a person.
Like if it's a person, it's like Sally, like Sally is blah, blah, blah. But when you keep saying like this, whatever apartments or whatever, it's just like impersonal versus my client. But if it's a person, personalize it with the name.
Well,
Yeah.
I was at one question. Did we ever say, well, actually, because I was going in and out to do cleaning things. Did we ever say what the actual phrase is that he said that revoked or shoot him?
No.
No, why didn't you?
I know, yeah.
Yeah.
I thought
Yes,
maybe
what?
that was a
Y'all kept
stipulated fact
saying-
that they could say it.
Pussy.
Oh, is that what it was?
Call
Oh,
her pussy.
Right.
Okay.
Oh, I would have said that.
Oh, yeah, I didn't know that. I mean, I read
If you
the highlight.
don't say it, we will always assume.
I thought it was a racial
the
slur.
worst. The worst
I thought that-
possible.
Yeah, well, that's what I was immediately assuming. It was some type of.
Or opposite, that it was like, you're a dummy. Like,
Yeah.
you know what I mean? Like, if you're not saying it, like,
Yeah, so you never want a jury that's my 2 cents about this. Not your word. And a lot of people are like, oh, I don't want to say the bad words. Like, I don't want to drop an F-bomb or something like that in court, right? You make sure it's very clear. It's like, all right, so we are saying we're in a court of law, judge, apologize in advance. What did he say? He said X. Right?
I thought it was
We
stipulated.
all know what the mysterious phrase is to the way
I
we all
just thought it
both
was stipulated.
answer. It's like, I wrote the problem. Hardy's like, did I write a racial slur? And then what is happening here?
Well, because also for pussy, a lot of people are, I mean, some people might be like, oh, that's what he called him? That's nothing, you know? Whereas if it's just a derogatory, yeah, he thought it was a racial
I thought it
slur.
was a racial slur, that's why I want you guys.
There's
to say
a lot of
it.
words,
I had no
right?
idea.
Like,
I didn't read the entire pack, I read the gist of it.
So my actual last comment or suggestion is for the experts. If you know they're probably going to come in, or if you've already stipulated the fact that they can testify in that capacity as an expert, stipulate. And when the other side is starting to like try to prove them up, you can stand up and be like, Judge, we stipulate, or we have stipulated to this person as an expert in this, category or in the field or whatever. And then see if the other side just stops putting on their credentials. Because sometimes the other side will be like, oh, okay, great, I can skip these, and then they'll just start asking the questions. The finder of fact doesn't understand like what all, like why they know and are experienced enough to testify and why you should care about what they say.
Judge?
Yeah.
All right, I'm Denise Brown. I'm the presiding judge of the 127 downstairs.
And one of my law school members.
She's like,
Yes.
I disagree with all those lawyers.
Literally 27 years later, we're still hanging out.
In my previous life, I was both a insurance defense lawyer as well as a plaintiff lawyer. So I feel the pain on both sides. I agree with almost everything that they said earlier. I also recognize that y'all had 70 minutes to put on a trial that would probably last anywhere from 3 to 5 days. So what you could and should and probably would have done is different in mock trial world than it is in real trial world. And I want y'all to take away from this advice for the real trial world, because that is what y'all live in now. You're not mock trial students. If the criticism seems harsh for what you had time to do in this case, it is not meant to be that way. It is meant to give you the opportunity to take what we're giving back to you into the courtroom in real life. So I don't have actually much to add to what has already been said. I just wanted to let y'all know that I think you've done a fantastic job given the constraints that you've had. The only thing I noted that has not been said is everything seemed really low key energy. And I recognize that you've been trying this case for 48 hours. And it is 6 o'clock on Sunday and y'all are done and you have to go to work tomorrow. I recognize all of that. It seemed like y'all were done with it, everybody, which is fair. It's fair. But it was kind of low key for it to be murder involving drug dealers and domestic violence and, DEA agents and all of that stuff. It seemed, even though most of the witnesses were just kind of like that. Yeah, thanks. I investigated crime. Sure did. So in the real world, because the jury will fall asleep and they will start writing down their grocery list. Instead of taking notes. Some parts have to be a little bit more exciting and you have to be a little bit more behind what it is that you're saying. That doesn't mean you have to put on a dog and pony show every single second. But a witness could have stepped down and I don't know, done something. Well, I don't know if there's a map. I didn't actually take problems. I don't know what y'all had, but if there's a map of the apartment complex.
Use what you got.
Circle where this one is and see how big, something, do something. I don't really have much else to add, other than I think y'all did a fantastic job. I think you should be proud of yourselves. And I will say that all 4 of you are welcome to the 127th anytime that y'all are gonna try things.
But not the 281st. Like, tip on all y'all.
What about the jurors?
Real quick before we announce the final round. They'll basically come down and put it, we'll work all the things.
Take the day off tomorrow. You all should take the day off tomorrow.
Oh, yeah, their bosses.
Yeah, I think you should talk to your bosses.
Well, so that's I saw him looking like, what?
Quick, everybody.
Oh, us, oh.
Everybody.
Because of that exact reason, and I just.
You were all tired, that's why I want to do the photo on the front end. And then.
Oh, you were, oh.
By the way, kudos to your bosses.
Yes. And I have no under.
You're so much into us.
All right, full body shot, so you see two of them again now. All right. Everybody smile. They go so cute. Yay! All right. Yay! So, first I'm gonna announce the outstanding applicant of the final round. And this goes to Cristen. Great stuff. Haha. Thank you.
Thank you.
And then we're going to do the finalists, so you know who won, but, give the finalists their moment, the picture. But the finalist is Sartain Lee, congratulations. Congratulations.
Thank you, Charlie.
And then you good job. Good. Which means congratulations to litigation rangers. You win. So what Whitney comes with is for 1 year, you get to hang on to this. So y'all can do some timeshare or whatever for it. I actually have photos of some of my former students. I'm not saying that's what you do, but I mean, it's literally yours for a year. And then the next one, you have to bring it back to me. To give to the next one, I'll get the plate engraved, put the name on it, and no on there. This is a custom tailor to package for each of you. My only request is that you send a card to Susan, no, to sticker for it.
Yes.
All right. And then because this comes back to me and will go to someone else at some point, he starts to turn to you so that you can keep forever and ever. That's the big one. The big one's much.
Oh, that's our team.
Yeah.
Don't record them out.
What, do you think it was like fake? Congratulations.
Good job.
Thanks so much. I hope you learned lots of things and I hope that we see you in real trial very soon. Thank you to all the St. Mary's people for, that was amazing that y'all drove all the way up to San Antonio.
Of course.
Dropping shit.
Nice to meet y'all. Yeah, good to see you, Shane. You guys did a great job.
All of you all.
Thank you.
Thank you so much. Andreas texted me like, who won? I said, the winners. And she was like, I was like, Contreras and Flanagan. She goes, that's my team. So yeah, congratulations.
Did a great job.
Yeah, but we're looking at accolades. That's what we were.
Maybe next time.
You got our seat.